This is going to be the first session on constitutional founding. Many constitutions have influenced the Indian constitution making process, particularly the American Constitution, both in terms of its history and its practice. But before I start that, I think I will just quickly take you through the agenda itself, which is we will have a short introduction or introductory sorry, one second. Sorry. We will start with a introduction of the readings. We'll take you briefly through the readings, followed by a short Q&A. And then we will have a student discussion for about 30 minutes based on the readings and 2 discussion questions we have. You will apply the readings to the discussion question and answer. This will be followed by part 2 of session 2, which will once again take you through a summary of reading set 2. We will have a short Q&A. If students have any questions, please feel free to ask, followed by a student activity for 30 minutes. After this, we will have Professor Arun Thiruvengadam, professor at NLSIU Bangalore, talk to us about constitutional founding moments in US and India. And he's actually given us a case for students to go through. So he will be using that case to articulate his points, followed by a short closing where we sum up the discussion and we end the session with that. So going back to the constitutional founding moments in India and the US. So the Indian framers had the American constitutional history and founding in their mind, and were immensely inspired by the American Constitution. And that can be seen with Nehru's quote when he introduced the Objectives Resolution in the Constituent Assembly. He actually went back to the constitutional founding moment in US and says, I think also of the various constituent assemblies that have gone before and of what took place at the making of the great American nation, when the fathers of that nation met and fashioned out a constitution which has stood the test of so many years, more than a century and a half, and of the great nation which has resulted, which has been built up on the basis of that constitution. So the American Constitution has had an impact on many provisions in the institution, on the Indian Constitution. For example, you could look at judicial review, which is enshrined in Articles 32 and Article 226 of the Indian Constitution. These are concepts that we were borrowed from and we were inspired by our American counterparts and included in our Indian Constitution. So let's now look into how the American Constitution that inspired our framers came into being. The American Constitution was drafted in the Constitutional Convention at Philadelphia in 1787. However, there were a series of events and documents which preceded this. For example, the Declaration of Independence, the Articles of Confederation, the state constitutions, and events even after that. For example, the ratification process, the Bill of Rights, all of which form a substantial part of the way we look at constitutional history and practice in the US. So I will take you through each and every one of these events. And we will start with the Declaration of Independence. So in prior to 1983, that is before the American Revolution ended, America was loosely a group of 13 British colonies. And these colonies started having conflicts with the British Crown on grounds of taxation, representation in legislative bodies, and therefore declared a revolt or a rebellion, which is commonly known as the American Revolution, which began in 1775. As this is going on, on July 4th, 1776, the colonists came together and came up with a Declaration of Independence from the British. This, in fact, inspired an Indian historical document, which we will look at when we look at the Indian Constitution making process. I would ask students to keep an eye out for that document. So this Declaration of Independence had 2 key points. One was that all men are created equal and that people have the right to choose their government. This equality clause, while it was there in the Declaration of Independence, didn't make its way to the American Constitution that was adopted in 1787. But we'll see how that plays out in a bit. So we have the Declaration of Independence. So colonies are now deciding, okay, now how do we govern ourselves? Now we want independence. What do we do to govern ourselves? So what they look at is they have something known as the Articles of Confederation, which they came together and enacted in 1777, which will determine how they would govern themselves at the national level. And they had several state constitutions at the state level. Now, what this Articles of Confederation did was it set up something known as a national government. This national government only had a legislative branch. There was no executive, there was no judiciary. But it was a very weak national government. It didn't have powers to raise funds, it couldn't impose taxation, it couldn't regulate interstate commerce, and it could not call for troops to fight. It had very, very limited powers and was a very weak national government. And the Articles of Confederation also had a very rigid amendment process. It was not easy to amend the Articles of Confederation to give the national government more powers. And because of this rigidity in amendment process, the Articles of Confederation did not solve the purpose that it was intended to. It was intended to do, which was ensure that there was proper governance during the war period. So essentially what happened because of these, in 1983, when the American Revolution ended and America won its independence from the British, these problems started becoming more acute. The lack of a proper national government or strong national government, the problems of that started having very material ramifications. And that's why in 1786, James Madison proposed, in 1786, James Madison proposed that they have a constitutional convention to amend these articles and ensure that there is a strong national government. This was endorsed by the Confederation Congress in February 1787. And they asked all the 13 states to send their representatives to this convention. So this convention were met in Philadelphia in May 1787, and essentially what they had about 55 delegates from 12 colonies. Rhode Island didn't send any representatives. Together, these 55 delegates unanimously chose George Washington as their president. And they debated for about 4 months up till September 1787 on what sort of government they want to have. So what the initial scope of this convention was to restructure the Articles of Confederation so that they have a stronger national government. But the way the deliberations went on in the convention is that they actually wanted a new form of government itself. And the new form that they were conceiving was it would be 3 organs of the state with a legislature, executive, and a judiciary, and a systems of checks and balances to ensure that each organ is functioning within its mandate. So once these deliberations concluded in September, five members drafted this constitution based on the deliberations. These 5 members included Alexander Hamilton, James Madison, William Samuel Johnson, Morris, and Rufus King. So these 5 members drafted, and on September 17th, 1787, we had George Washington sign the constitution that was adopted. Now that the constitution has been adopted, just before I move into the process, I just wanted to highlight that the constitution was very, very small. It merely had 7 articles. The 7 articles focused on establishing the 3 organs of the state, declaring the constitution as the supreme law of the land, the amendment process, interstate relations, etc. It didn't have any provisions on civil liberties that we do see in our that we had from the beginning in our Indian Constitution. So now that the Constitution was signed, the Constitution had to be ratified by the 13 colonies. So this ratification process began in December 1787. And during this, what James Madison and Alexander Hamilton did is they published a series of 85 essays known as the Federalist or the Federalist Papers. And these essays were used to convince people or persuade people to ratify this constitution. So they highlight the features of the constitution, the merits of the system that they've adopted, so that people would ratify the constitution. The ratification process ended in May 1790, with Rhode Island being the last state to ratify the constitution. Now that this constitution has been enacted, it has been ratified, we move to amendments. What happened after the constitution has been adopted and is in force? Interestingly, Madison, who in the newly established House of Representatives in 1789, proposed that they would have 19 amendments should be made to the Constitution. Out of these 19 amendments, only 10 were ratified. And these 10 amendments essentially had, commonly known as the Bill of Rights, had features such as freedom of speech, freedom of religion, freedom to assemble. And these Bill of Rights were enacted in the Constitution in 1791. Including the Bill of Rights, the American Constitution has had only about 27 amendments till date. And interestingly, if you contrast this with the Indian Constitution, which has had about 105 amendments as of August this year, it's interesting to see how a constitution of longer duration has had only about 27 amendments, and a relatively newer nascent constitution has had 105 amendments. This speaks to the volumes of, one, the process of amendments itself, and the ideas of rigidity of the constitution. So with this, I think we should, with this background in mind, look at how the Indian Constitution came into being. And we have a short video that we have produced, an animated video that tells us how the Indian Constitution came into being.
Can you see my screen?
Yes.
Okay, I'm just gonna play.
We the people, having solemnly resolved to constitute India, battled the British for over a century on the streets and in the courts and assemblies to realize our collective desire for freedom from colonial authoritarian rule. This found an early voice in 1895 with the Swaraj Bill, which demanded a dominion state with equality for all and freedom of speech. In 1928, Motilal Nehru's report went further to call for self-governance and minority rights. However, both demands fell on deaf ears. So on 26 January 1930, the Indian National Congress declared Purna Swaraj, or complete independence, discarding the demand for dominion status. A year later, at its Karachi session in 1931, the INC demanded comprehensive social and economic rights. Sensing imminent change, M.N. Roy proposed a constitution drafted by a Constituent Assembly of Indians, by Indians and for Indians. The INC embraced this view, and after years of relentless negotiations with the British, a Constituent Assembly was created in 1946. Nearly 300 members, representing all shades of political opinion, diverse religions, ethnicity, and from all over India, met in the plenary assembly and subcommittees across 3 years to draft India's constitution. They made deliberate and radical constitutional choices to first, transition India from a colonial authoritarian state to a constitutional democratic republic with adult franchise and representative legislatures and independent courts to maintain the rule of law. Second, to transform a traditional society built on caste hierarchy and patriarchy into a modern egalitarian society based on every individual's dignity and fraternal relations between them all. Third, usher in a multi-religious secular democracy by assuring individual freedom of religion and keeping the state away from organized religion. And lastly, to restructure a feudal economy based on concentrated or inherited wealth and large landholdings by distributing land and other economic resources and ensuring social and economic welfare. Finally, this new Constitution Republic was born on 26th January 1950. 7 decades later, our Constitutional Republic needs you to be a Constitution defender, to preserve, protect, and realize the progressive constitutional dream to build a new India.
So now that you have a fair idea of how the Indian and American constitutions came into being, do any of you have any questions for me before we move to the student discussion? You could even type it out in the chat box if you don't want to speak, that's fine too.
Yeah, hi. I just had a question.
Yes, no, tell me.
Yeah. So, like, I was going through this particular reading yesterday, and it was told that slavery was not abolished in the initial American Constitution, but the Declaration of Independence previously had adopted equality as a clause. But you were also mentioning that it didn't find way into the American Constitution. So, like, could you shed some light on when exactly anti-slavery provisions were incorporated into the Constitution?
So essentially what you see is after this you had the Civil War, right? Which is, so let me just give you a little background on the delegates who were there in the Philadelphia Convention. So the Philadelphia Convention itself had members who were predominantly white men, who were aristocrats, who were lawyers, and who were slave owners themselves. So when the questions of slavery came up, they were unable to reach a consensus. And at that point, with just new independence and the need to have a strong national government, questions of slavery were then left out because it was so contentious. But after that, you do see with the Civil War and then the divide between the North and the South. And subsequently, in terms of equality itself, the equality provision came in with the 14th Amendment in 1868. It was only in 1868, the 14th Amendment, which brought in a strong equality or an equal protection clause in the American Constitution.
All right, thank you.
No problem. Thanks. Okay, in case there are any questions, you can ask me throughout the process. That's not a problem at all. I'll probably start with the student discussion question. And so we'll start. We have 2 questions for you. And how I'm going to do this is, 1 second, start the PPT. So we'll start with the basic question on how you think constitutions should be made. Do you think constitutions should be made democratically? What are your thoughts on this? Anyone has any thoughts can start.
Hello, am I audible?
Yes, we can hear you.
Yeah, my name is Vismay.
Yeah, hi Vismay, tell me.
And just to kickstart this discussion off, I would like to state that I do believe that constitution should be made democratically, because what essentially is a constitution? It's based on a principle of constitutionalism, right? So what that essentially entails is that there should be a sort of limit that is imposed on state action. Like if you look at the Indian Constitution, for example, Part 3 guarantees fundamental rights. And what that essentially entails is that the state can't encroach upon these rights that are provided for by the Constitution. So I I believe that if a constitution was not made democratically with proper representation from different sections of society, you can't really incorporate all of the interests of various sections of society within the constitution. And also, as we know, a constitution is a grand norm and the basic legal document of the land, right? So it has to be all encompassing and take into account the interests of all sections of society. So that's why I would like to state that yes, a constitution should be made democratically.
Hi, my name is Mohammed.
Yeah, hi, Mohammed.
Yeah, so we should essentially ask, why should constitutions be made democratically? Why are we, insisting on a democratic veneer for a constitution? Like the Government of India Act 1935 is a constitution. It was not exactly made by us. We still retained a large part of the act into our constitution. So a reason why constitutions must be made democratically is because it contains or carries a veneer of legitimacy. So it, convinces people or, the ruling dispensation itself that, this is a constitution that has legitimacy. So there is a, legitimacy is attached to the exercise of power and lawmaking and, all the associated acts. So that is one reason why constitutions must be made democratically. But do democratic constitutions make the best constitution? Not necessarily. For example, the Zimbabwean constitution is probably one of the most democratic constitutions ever made. It had the most popular participation in the world. So that exactly did not pan out well, because we know how Zimbabwe ended up with that constitution and the instability that plagues the country. So having a democratic constitution, having stakeholders involved in a process does not really guarantee that that will be a grand success. And in order to ensure that it is a success, there has to be a participation of experienced individuals, people who are experienced in constitution drafting, critique, like B.N. Rao did for our constitution. And it is given in the reading materials itself that Gandhi had this idea of parachuting certain individuals from law and politics into the Constituent Assembly, so that there's a bit more nuanced approach to constitution making, because we know that a lot of members in our Constituent Assembly did not really subscribe to the view of constitutional democracy we have. So yeah, that's my view on that.
Thank you, Mohammed. Does anyone want to add anything to what Mohammed has said, or to what Ms. Bismay said earlier?
Hi, my name is Neetu.
Hi, Neetu.
Yeah, adding on to what Vismay said, considering a country like India, a democratic constitution is very important, considering all the different minorities, ethnicities, everything, in order to build the trust and the coordination among the people, and to know how the government is formed. I personally think the constitution should be made democratically.
Hi, this is Naveen here. I just want to add on to what Neetu just mentioned. Like we need to look at the constitution from the perspective of when it was being drafted as well. Several princely states wanted independence. They wanted to be independent. Pakistan wanted to be formed separately. And there was a lot of instability, and to get different people, especially given that India is extremely diverse in a lot of aspects like religion, culture, and languages as well. It was very important to make the constitution making process more democratic, so that it made everyone felt heard and included in the drafting of the constitution. So for that reason, I think equal representation of all groups were important. And I was going through the reading materials, and they were very strongly in favor of the fact that the Congress party, which predominantly constituted the Constituent Assembly, was very diverse in terms of minority representation, and to a certain extent caste representation. So I think for that reason, and even geographical representation, they mandated that certain number of people from the Madras province, certain number of people from the Bihar province, and in that, say, a few Christians, a few Muslims, and a few people from the scheduled caste had to be included. So I think for that reason, including all these diverse voices gives more representation to different people, their needs, and so that all of these things can be equitably represented in the constitution, which basically at the end of the day upholds human rights for all of us.
Hello, am I audible?
Yes, Vismay, you're audible.
Yeah, so I just wanted to ask a question or raise a point of discussion with regard to what Muhammad said. He was speaking of a constitution being a success, right? In terms of having individuals that are trained politically or legally, taking part in the constitution making process. He raised the example of the Zimbabwean constitution being one of the most representatively enacted constitutions. I want to know, like, in terms of efficiency, yes, maybe that it's easier to like probably discuss and draft the constitution if you have legally trained minds. However, isn't the very idea of having a constitution trying to protect the rights of persons who aren't represented in the drafting process? So like how do you like reach a balance between this, and what in his opinion is a successful constitution?
That is a very generous view to take about constitution drafting, because we all know the Declaration of Independence says all men are equal, but there is a Supreme Court case that actually says when the men in United States said all men are equal, they didn't really mean slaves, because slaves are property. So constitutional drafting need not always take in the marginalized interests or minorities, or people who are excluded. So that can happen, and we have in our own country, discrimination on basis of sexual orientation was perfectly permissible until the Supreme Court came along and said, maybe not, analogous ground, so let's strike this down. So that need not always be the case. So you could have a lot of interests come in, but it's not always possible to include all interests. But that is something ideally, something we should ideally strive for. As far as what I meant when I said success is constitutions that provide stability and endurance and fairly okay representation. So that would be what a successful constitution is. But this could change from people to people.
Yeah, I mean, I can stand behind that argument, I think.
Yeah, just adding on to that. So basically, like if we go through the Constituent Assembly debates, it's very clear that every single word which has been put in there, like even structuring the sentence and looking at it maybe as a positively worded right or a negatively worded right, has been debated endlessly. So it's very important for someone who is legally trained to engage in these debates. And like there was a reference in one of the articles that there were four extremely eminent and well-read individuals. I don't remember the names exactly, but they refer to Ambedkar, Nehru, and a couple of others. So they were saying that such people who were well-read in constitutional history and who have read how the other constitutions in the world have worked out, like not just drafting, but actually implemented and how effective it was. It's very important to take such people who have views and who are well-read into the constituent drafting process.
Agreed. I just wanted to raise another point. Just this speaking completely theoretically here and not with regard to the Indian Constitution. What if you had a situation where you had just persons belonging to, say, higher nobility or whatever, who were conferred, special titles by, say, the reigning monarch, and all of them had like these titles that have been granted to them. What if they were the only persons who were engaged in drafting of a constitution? Do you think that there is a scope for the inclusion of, say, an Article 18 in the constitution? Because obviously, because they're the only ones who are taking part in the constitution making process, they're not going to incorporate an article that abolishes titles, right? So, I mean, I guess this is something to discuss as well.
Thank you, Vismay. I think we have a lot of points to ponder over. So what I'm going to do is just take this conversation a little ahead, and actually some of the points have already been brought out in this discussion. Is do you think the American and Indian constitution making processes were democratic enough to start with before we, so to tie in some of the points that you had raised on representation, so maybe you can discuss a little bit more on how the Indian and American constitution making processes were democratic.
So if I could start this discussion off, primarily I didn't read much into the American process of constitution making, but with the little I read, it was pretty clear that the voices of the Black people that were the erstwhile slaves were not taken into consideration at all, and mostly it was the rulers of the British colonies who constituted their own state constitutions and later on went on and ratified the national constitution. So I don't really think, from my understanding at least, I didn't find that to be a very democratic process. And primarily, it has to be looked at the perspective that when the constitution was being framed in America, slavery was still legal. So, apparently, I read somewhere that slaves were considered to be 3/4 of a person. So, and that is very humiliating that such statements were made during the Constituent Assembly discussion process. So that speaks to how democratic it is. I may be wrong as well. But yeah, and coming to the Indian Constituent Assembly debates and all of those things and how well people were represented, like I previously mentioned, the Congress party was very particular in ensuring that there's a diverse range of voices which are represented in the Constituent Assembly. So like I mentioned, like geographically they were represented and religiously they were also represented, and there was a certain amount of caste representation as well. So there was some caste statistic given wherein it said that there were 9 Brahmins and 1 Harijan, which was Ambedkar, and 7 other people who were not upper caste people. So to a certain extent, I feel that it was reflective of the diversity that we have in India. And yeah, so that's about it.
Thank you, Naveen. Anybody else have any responses?
Yeah, ma'am. So adding on to what Naveen was saying, I think the elections of the Constituent Assembly, I think only 29% of the entire population of India could actually vote. So that could be because of the country was just forming and not a lot of people were actually even knew that they could even vote. But the thing was, only 29% of the people were represented actually, even though the Constituent Assembly, like he mentioned, had a lot of diversity. For example, I think there were 9 parties, which is a lot, and a lot of other people were represented. So I think it is very diverse for the political situation at the time.
Thank you, Shivaram. Interestingly, about representation, even Jaipal Singh Munda, who was a member of the scheduled tribes in the Constituent Assembly, remarked about the lack of representation of scheduled tribes in the assembly. And in fact, there was no scheduled tribe woman at all in the Constituent Assembly. So any of the women here feel that the Constituent Assembly was representative, considering we had only 15 women members?
Hi, I'm Megha. So
Hi, Megha.
I'd like to add to that point. So if we're limiting the constitution making process to just what was given in the reading material as just when the constitution was adopted in both countries, then yes, there are issues with representation, but with women in both the constitution prior to the amendments the US Constitution did not consider women to be as equal as men. And with the Indian Constitution, our representation in the Constituent Assembly was pretty poor. But then there's the question of where does the constitution making process end, or has it ended with just the adoption of the Constitution? Because coming to slavery in the United States, it was abolished through the 13th Amendment, which was and if you consider that as part of the constitution making process, because the constitution technically hasn't ended as soon as it was adopted. And similarly for India, all the progress that we've seen with our constitution as well, it is still ongoing. So having processes in the constitution which allow for development or allow for progress in terms of representation or any other matters, doesn't that make the constitution or the constitution making process democratic enough? So I would say, if we think about it that way, then yes. But if we limit it to just the adoption, then the answer is no.
Thank you, Megha. That was interesting thing to think about what constitution making processes itself mean. Any responses?
I think I'd like to add to it. Am I audible?
Yes, Madhi, we can.
Yes, Madhi. Yeah. So I think I'd agree with all the points that everybody's brought up till now. But I mean, if you look at it very strictly in a comparative perspective, we didn't have any Federalist papers. We didn't have any referendum campaigns, so to call. We didn't have any participatory forums like America did. Of course, America is not exemplar in this situation. I think we've clearly established that. But the limitations, I think, as Megha brought up, of the amending process are also considerable. Because the fact that the wishes and the needs of indigenous peoples and African Americans were originally considered irrelevant, and that those of women were considered to be represented by men, that I think left the American polity with long-term problems. And on a comparative perspective, I'd say India was far-sighted in that sense. So probably a sub-layer that we have to look into here is the effect of the constitution what is important and what should be democratic, or is the making in itself democratic? Must that be democratic? And also, what is this sense of democracy that we're discussing? Is it a 21st century sense of democracy? It can't be, because the context and circumstances were very different back then. America's constitution was drafted 200 years before the Indian constitution was even thought about. So then we'd have to consider what is the degree of participation that we do expect. Representation, of course, but contextually speaking, America had, if I can call it, a transitional phase from its declaration of independence to exploring various systems of governance, of national governance as well, before they could arrive at what was then the American Constitution. Whereas India didn't have that. It was quite abrupt, if you look at it in that sense, because we only had 2 years and a number of days to then come up with a constitution which incorporated best practices from around the world. So yeah, I think these are some things that we can bring up for discussion.
Thank you, Madhi. That actually pushes us to think about how maybe democracy is not just through representation, but through processes also. And some of the processes Madhi had highlighted with the Federalist Papers. Anybody else want to comment on this?
Yeah, I just have one point. So adding on to what Mahati was saying, we need to look at the constitution drafting process from the perspective of the time when it was drafted as well. So like there was a mention of citizenship being provided only to men in the American Constitution when it was being drafted. So that is very problematic given the situation of women at that time in the US. But comparatively, when we look at India, citizenship as a concept itself was not restricted to gender. So I think there arises the difference between the time when these constitutions were drafted and like how we have to approach it depending on the time when it was drafted.
Thank you, Naveen. Anybody else have any questions, thoughts?
To add on to Naveen's point, I'd also like to highlight where India seems to be a bit more progressive would be that the Federalist Papers were required for certain votes to come into the favor for the constitution to be adopted. While in India, it was a debated process where the representatives could voice their thoughts and debate through it. Yes, there were parts where some representatives were able to perhaps put their point across in a more convincing manner, or they had the support of the Congress Assembly Party. But even then, when it comes to the US Constitution's adoption, it required a lot more convincing, a lot more arguing and imposing perhaps of three people's wills, whereas there was a more democratic aspect to the Indian constitution making process.
Right. Thank you, Megha. All right. In that case, actually, brilliant points have been raised by all of you. And these were the points we also had in mind, and most of them have been addressed in the discussion. First is the manner that the framers were elected itself. Indirectly elected, yes, as highlighted by Shivaram. And the question of representation, yes, maybe the Indian Constituent Assembly was fairly more representative than the American counterpart, but yes, we do take into account the time and the history or the historical context in which these two constitutions were made. The third is processes itself. So if you look at it in the Indian context, we had a process where there was the plenary assembly, which was the main assembly, and then there were multiple committees. So then there would be discussions back and forth. So the committee would give a recommendation, the plenary assembly would discuss it, debate it, push amendments. So that sort of deliberative process that sort of also is a sign of a democratic process because of deliberation, debate, and engagement with the provisions. And which was probably in the US context, we could see that maybe with the ratification as a process, making it slightly more democratic, ensuring that within the federal structure that the states have a say in what they do choose to have as the national government. So these were the 4 points that came to our mind as well, and they've been fairly discussed and deliberated in this student discussion. So we will move to the second part of this session. So Kalyani will take over.
Thank you, Meenakshi. Good morning, everybody. My name is Kalyani. I work with Meenakshi at CLPR. I'm going to quickly take you through the second part of the constitutional founding session, which is about the doctrine of separation of powers in particular. And over here, what we're going to do is sort of go through the two main resources that tell us about separation of powers in both the Indian Constitution as well as the American Constitution. For the American Constitution, of course, it's the Federalist Papers, which Meenakshi has explained to us in her earlier presentation. It's a collection of 85 articles and essays, which was written by Hamilton, Madison, Jay, under a collective pseudonym. And they did this to, of course, promote the ratification of the United States Constitution. For the Indian side of it, the resource is the Constituent Assembly debates itself. I will start with the Indian side of the doctrine on separation of powers. But first, we thought it was important to highlight Ambedkar's speech on 4th November, where he differentiates between America's presidential system of government and the parliamentary system that the draft constitution proposes. So over here, he says that under the American system, the president is the chief head of the executive, and administration is, of course, vested in the American president. Whereas in the parliamentary system, the president is merely a ceremonial, almost symbolic head. The American president, on the other hand, is not bound by the advice of his secretaries. Whereas in India, the presidents can't do anything in contrary to the advice of his ministers. Again, the American executive and legislature are separate, which means that the president and the secretaries cannot be members of the Congress, while in India, the ministers are members of the parliament, and only members of the parliament can become ministers. Both, of course, he said, are democratic executives. However, the American executive, he argued, was more stable, while the Indian executive, he said, was a responsible one. The draft constitution, of course, states that the Indian constitution would be a federal constitution. However, he differentiated it from the American dual polity, because America has dual citizenship, as well as they give each state a certain sense of rights of its own, which is very different from what we have in India. Then later on in multiple other speeches, actually, Ambedkar talks about the importance of separation of powers. So over here, he says that the judiciary must be both independent of the executive as well as competent in itself. And while stating this, he argues that it was dangerous to leave appointments by the president of judges to the Supreme Court, of course, without any limitation. So he says, one, it's dangerous to leave appointments of judges to the Supreme Court by only the executive. Two, we can't give the same power to the legislature either entirely, because they could then be influenced by political pressure or political considerations, and it would be a very cumbersome process. And three, he also says we can't leave the power entirely to the Chief Justice themselves. So we have the current article which says that the judges would be appointed by the president in consultation with the Chief Justice of India. Then in another speech on 27th May 1949, there was also an intervention by Ananthasena Mayangar, where he states that every constitution should provide for an independent judiciary, executive, and legislature. All three are equally important and independent, he argued. Over here, he said that if the salaries of the judiciary were to be fixed with an approval of the president, it destroyed the independence of the judiciary, and the rights of the judiciary shouldn't be reduced in such a way. So almost as a response to Iyengar, B.R. Ambedkar of course agrees that the independence of the judiciary from the executive needs to be as clear, especially by way of law. However, he says that we can't create an imperium imperio, which is almost a supreme power of sorts. And he states that the judiciary should be able to also act without fear or favor of executive. So he's trying to build a balance between the two, where we're not giving the judiciary extreme power, but also they're able to act independently without fear of intervention from either of the other two organs. He also offers that maybe the constitution could later be amended in a way that the government of India was, where it states that in case there was a conflict between the executive and the judiciary, because the executive determines the budget for the judiciary, then the Governor General could intervene to come to a conclusion. In another speech that we thought was important, which is on 7th June 1949, Ambedkar states that, of course, again, that there needs to be a separation between executive as well as the judiciary. And over here, he mentions that when a person is holding one office, they must not hold another office simultaneously. This he thought was of utmost importance. But he also felt that because the judiciary deals with the adjudication of rights, it's not usually concerned with the executive. And similarly for the executive, he thought they wouldn't ideally intervene in matters of the judiciary. So those were the Constituent Assembly debates that we thought were important to highlight what the framers thought about the separation of powers. We can now move on to Federalist number 51. Thank you, Meenakshi. So Federalist 51 was the 51st paper of the Federalist Papers. As I said earlier, there were 85 of them. This one is titled, "The Structure of the Government Must Furnish the Proper Checks and Balances Between the Different Departments." In this document, this is written by James Madison. Madison addresses means by which appropriate checks and balances can be created in a government, and it also advocates a separation of powers within the national government. Madison argues that separation of power is essential for the preservation of liberty. This he borrows from Montesquieu. Montesquieu declares that in order to preserve liberty, it was essential that no one single person or one group will exercise all of the three powers of the organs. So he borrows the idea of separation of power being essential to the preservation of liberty from Montesquieu. He then goes on to argue that all appointments for the Supreme Executive, Legislature, and Judiciary should be drawn from the same fountain of authority, which is the people. So he argues that all appointments should be done by way of election. However, he says that the judiciary might not follow this principle because the constitution of judiciary would require people with peculiar qualifications, and only people with these qualifications can be essential members of the judiciary. But he also states that the permanent tenure that the judicial members have in America will sort of destroy any sense of dependence that they have on the authority that confers that power on them. He also says that each power should have, each department should have a will of its own, and it should be constituted in a way that each member will have as little agency as possible in the appointment of members of the other departments. He also says that security against a gradual concentration of several powers is important. So he says that you need to provide each department with their own constitutional mean and personal motives to resist encroachment from other departments. And he talks about human nature and how it's important to almost pit one department or the people in one department's ambition against the ambition of the people in another department. He then highlights that independence of branches is enhanced by making the members of each branch as little dependent on the other, especially for salary, similar to what Ambedkar argues, but not exactly the same either. And he says it's also important to divide and arrange several offices in a manner that they create a check and balance on each other. He warns that the legislative branch in America could be the strongest branch, and the only way to counter this could be to divide the legislature in and amongst itself, or to strengthen the executive to counter their power. So I think that's a detailed enough brief on Federalist number 51. I will actually like to pose the activity question first so that you guys can go through that, and then maybe we will open up to questions and also divide you into break rooms so you have a certain amount of time to discuss the question. So here is the proposal that we have. So there's a proposal to introduce a commission to appoint judges to a Supreme Court. Now this commission will comprise of 4 people: the Chief Justice of India, 1 senior judge of the Supreme Court, the Prime Minister of India, and the Law Minister. So that's 4 of them. And 3 out of these 4 people must give their assent for every single appointment. So every judge that is appointed has to be approved by 3 of these 4 people. Now, what we want you to see is how, 1, James Madison would react to this, and B, Dr. B.R. Ambedkar would respond to such a proposal. If you have any questions, feel free to ask us questions right now. Meenakshi and I can help you before we divide you into 2 groups. And then one could argue what James Madison would say, and the other side could respond to what B.R. Ambedkar would say to such a proposal.
I have a question. So I got a point about what James Madison would have argued about separation of powers, but could you just very quickly tell me what Ambedkar's point of view is about separation of powers? Like, where does the difference lie between both of them?
So that's what we want you to see, because I think that's what we want to highlight through the discussion itself, because they both, of course, they agree that separation of power is an important aspect of the constitutions, but they differ in very small ways, almost in the manner of reaching the doctrine of separation of powers. So I believe maybe once we break out into the rooms and have the discussion, it might just come out in discussion. So I'll leave that for the end, if that's okay.
Okay, all right.
Okay, if there are no questions, Meenakshi, maybe we could divide them into 2 break rooms.
Yeah, I'm just going to do that.
Yeah. We will then tell which.
Yeah. I think we have all students back from the discussions. So should we start with the group representing James Madison?
Breakout room number 1, I believe.
Yes. Just a second.
Sure.
Hi, Gina.
So representing Team Madison, we would think that he would be favorable to the current proposition because of two main reasons, two main elements. I think Meka would elaborate on the same. The first one is with regard to the element of check and balance. In this case, Madison strongly believed in separation of powers. And in this case, as we can see, there are two members from the judiciary, the Chief Justice and a senior judge himself. And there are people from the executive side as well, the Prime Minister and the Law Minister. So there is a very good, and of course, the point that for appointment to be made, there requires a majority vote. There requires 3 people to vote for it. So there is great sort of check and balance in this case. No one particular organ has an upper hand in this case. And it also helps in checking nepotism to a great extent, because if we completely give the authority to the judiciary, then there's a great chance of nepotism creeping into the appointment process at large. Another major point that we could find when we were reading at the materials is that Madison believed in this theory of ambition checking ambition, ambition versus ambition. So here, since there is executive representation and judiciary representation, and since there requires 3 people's vote, I think the ambition between he called it departments, right? So the ambition of these different departments would in itself ensure that the most perfect candidates are elected or appointed rather to the position. The second point is with regard to needing a merit in judiciary. Even though Madison believed in the will of people and all of that, he also very rightly diluted that concept when it came to appointment in judiciary. As you also presented in the presentation, when it came to judiciary, he believed that people who are involved in the appointment process need to have the merit and understanding of how the judicial process works and what a judge should possess. So in this case, I think it is fine to have these people in the committee because there is adequate expertise in the committee to select the right members to be appointed as the judges. So these are the 2 main points that we could come up. If Meka has anything to add, I request Meka to add.
Thank you, Juno. So he clearly made the points that we could figure out from our deliberations. Just to add on to that, so with regards to the merit argument, we also looked into like the bare bones of the separation of powers that Madison envisioned and figured out that there was popular participation was a concern, if that is not the main concern with the judiciary. However, it was a part of his vision as separation of powers. So even in that case, this model represents it in a certain sense. Another thing that I'd like to highlight is that if you juxtapose this model with the current situation in the United States, where the president gets to elect the judge, then you see that right now there has been a political leanings towards the Supreme Court. The Supreme Court is seen as liberal or conservative, and that's the current model that they have. And this doesn't align with what Madison envisioned for the separation of powers is what we've seen so far. So given this model, it would certainly seem that Madison would prefer this over what they currently have. So adding on to Gino's 2 points of there being a check and balance and the ambition versus ambition part, and also the fact that there are merit in the candidates involved in the election, those who elect, then we believe that Madison would agree with this.
Sorry, just to clarify, could you detail a little bit more about when you said how there wouldn't be any political pressure on this election process? Appointment process, to be specific.
We did had that in our deliberation also, like what would happen if one of the judges lean for some political favor or pressure. One thing that we could note is Madison believed that there won't be so much of an issue in appointment from the executive side because they're appointed for life. So their allegiance does not lie only to one particular party or one particular president for that matter. Since they're appointed for life, their allegiance is to the state itself at large. So I think this model kind of goes along with that proposition. If Meka has anything to
So that is it. And if we are contrasting it with the current situation where it's just the president, you see that there is more of a political aspect playing there as opposed to what would have happened if this was this model adopted.
Okay, thank you for your points. Maybe before we ask you guys questions or pose any discussions, we could ask group 2 to tell us their view on what Ambedkar would have thought about the commission.
So we had polarizing perspectives. So one was that Ambedkar would have agreed to this proposition, and another was that he wouldn't have. And I think, I proposed that he wouldn't have. And like, if you look at the way he's structured his speeches in this during the separation of powers debate, you can see that he is clearly for a clear division, a demarcation between the powers of the executive and the judiciary. And in fact, all the articles that relate to like the High Court, the Supreme Court, all of those things. But the question that he really was not for was how many years should a person hold judicial position, and how many years should an executive be in such an administrative position for them to be able to exercise maybe judicial powers. So where is that line drawn, right? So there wasn't necessarily a rigid separation that he supported. I'd say what he did advocate for in effect was that there shouldn't be any influence that affects the independence of the judiciary. So the independence of the judiciary is something that he did advocate for. And theoretically, if you look at it, the other side's perspective does stand, that them holding the post in itself might not necessarily imply an effect of, an influence on independence. But practically, if you look at it, and the reason why the NJAC was also shut down was because this co-equality will not be reflected if the executive will be allowed to appoint judges to the Supreme Court or be involved in the entire process. So this was the opposing perspective. I think I'd give the floor to Mohammed to give the proposing.
So I, from what I read, I feel like Ambedkar would have gone along with the proposal because one, Ambedkar imagines a very weak separation of power, because he himself states that his intent is to ensure that there is no imperio in imperio, and the power must be balanced. So he himself says, to look at the provision under the Government of India Act, wherein judges are appointed by the Crown. So he's like, so this is where we are coming from, and you don't really have to go to consultation because the system has worked fine so far. So why should we change it? So Ambedkar does have a very conservative approach to it. He doesn't really want to disturb that system. And if he himself says, while dilating on the role of a court, he himself states that at best the court will be concerned with issues between the state and rights of citizens. I do not think Ambedkar was fully cognizant about the clash that would transpire between the executive and principally the executive and the Supreme Court or the judiciary. So Ambedkar would have, because there is like equal representation from the judiciary and the executive, Ambedkar would have probably said something like, see, this is a midway. This does not really concede significant ground to the legislature, nor does it, or the executive, nor does it concede it to the judiciary. So there is, this fear of empire within empire being snuffed. Another point is that Ambedkar imagined a very, very utopian concept of responsible government. So I do not think, he might have probably thought, even if these members of, if the law minister and the prime minister makes a responsible choice, they would have probably been held accountable by the legislature, which is not the case at all. So if we are talking about the practical implications of these appointments, I do not think Ambedkar was really imagining what this would look like in the future. So I think Ambedkar would have gone along with the proposal.
I think some fair points were raised. I actually have a couple of questions, and actually Professor Krishnaswamy has also added some questions to the chat box. Maybe I will repeat that before I delve into my questions. So Professor asks if Madison is concerned with an overpowering executive or judiciary. I'm assuming this is for room 1. While for room 2, he asks if Ambedkar would be concerned that the political majorities would overwhelm minority protections. And I have a similar question to group 2, actually, where I wonder if, although of course it is creating some sort of checks and balance, the fact that 3 of them, there needs to be 3 out of the 4 to vote for a judicial appointment, would that then mean that some sort of political pressure would come into play while electing judges to the Supreme Court? And for group 1, I was also wondering if the point about pitting ambition against ambition, wouldn't it then mean the executive would favor someone who's not good because you're pitting one department's ambition against the other, which means that maybe the executive wouldn't want the judiciary to have probably well-qualified judges? Anyone can answer the questions. It's open for discussion.
Yeah, I was just going through the Federalist Paper 51, and in that paragraph 56 states that Madison believes that the legislature should have a more overpowering power compared to the other wings. Like, he believed that they would have more power, not that he wanted them to have more power, because they represented the will of the people. So they were much more stronger compared to the other 2 branches.
And I believe he also provided ways to check that by either dividing up the legislature or making the executive more stronger. Anyone else from either groups to, or you can even ask questions to the other group.
Replying to what Kalyani asked, so B.R. Ambedkar, on his speech on 7 June 1949, he specifically said that the judiciary to a very large extent is not concerned with the executive. It is concerned with the adjudication of the right of the people and to some extent to the right of the government of India and to units as such. So the opportunity for the executive to influence the judiciary is very small. So I really don't think having as far as in your, I really don't think it would have an influence.
Would you still say that in today's scenario?
Not really, but then theoretically, it's like that.
May I?
Go ahead.
Yeah. So I think to answer Professor Sudhir's question and yours, this whole idea of the collegium, I think, was mooted and to be an alternative to the model which was actually suggested by Ambedkar himself. And I think it's even mentioned in one of the speeches that you put up, the 24th May speech. And he had shown disinterest in the executive and the Chief Justice in the appointment of judges equally, not just the executive. But yeah, so I think that's where he suggested this whole scheme of appointment of judges under which the executive and the judiciary would both have a say. So I'd say he was a little confused, if I may put it like that, controversially so. But that's what I think caused a turn in the Supreme Court judgments themselves, to shift the balance of power while at the same time coming up with a minimalist approach to the whole selection process. To answer Sudhir sir's question, I think he certainly knew what minority interests meant in appointments and also in political interests. So practically speaking, I don't think he would have been for this whole system, the whole model that's been created by the judiciary. Although it's different from the one that's suggested by Ambedkar, what is present today, it's one of the ways in which the independence can be maintained, and that in itself is what he advocated. So yeah.
Thank you. Okay, so I do think some very important points were brought up during this discussion. And what we wanted to highlight was that although both Ambedkar and Madison arrive at the same conclusion, they almost do it in a little different manners. And this is possibly because, of course, probably is because both the systems that are followed in India and America are very different. Specifically because when Madison talks about how the tenure will give independence to the members of the judiciary, it's because they are elected for life, and it's not the way it is in India. And the reason we thought it was important to do this activity is to sort of engage in constitutional law issues as well as historical arguments that make it what it is today. And yeah, we hope you found it interesting. And I think it was a very engaging conversation. Meenakshi.
Yeah, absolutely, I agree with you. I think we got a lot of points to think about, a lot of points to ponder over as well, which we couldn't probably conclude in this session. We'll now move on to the next item on the agenda. We have with us Professor Dr. Arun Thiruvengadam, Professor of Law at the National Law School of India University, Bangalore. His teaching and research interests lie in the areas of constitutional and administrative law in India, comparative constitutional law, law and development, law and politics in South Asia, and welfare rights. Between 1995 and 97, he served as a law clerk cum research assistant to former Chief Justice of India, Justice A.M.M.P. at the Supreme Court of India. He practiced law for approximately 2 years before the High Courts of Madras and Delhi and the Supreme Court of India before commencing graduate studies in 1999. Arun is a founding editor and currently the co-general editor of the Indian Law Review. He also serves as an editor with the Asian Journal of Comparative Law at Cambridge and World Comparative Law. Arun has held research and teaching assistant positions at the National Law School and New York University School of Law. He was successively visiting fellow and an assistant professor of law at the Faculty of Law, National University of Singapore. In 2015, he joined the School of Policy and Governance at Asim Premji University, Bangalore, where he worked for 6 years. He's taught courses in a visiting capacity at many institutions, including the University of Zurich, Switzerland, Central European University, Budapest, School of Law, City University of Hong Kong, University of Trento in Italy, and the West Bengal National University of Juridical Sciences, Calcutta. In November 2019, he was appointed the James Merrills Fellow at the University of Melbourne Faculty of Law, as a part of which he has delivered 2 public lectures in Melbourne and Sydney. He's previously taught as the Distinguished Faculty at the Faculty of Law, University of Toronto, Canada. Thank you so much, Professor, for joining us today. The floor is yours.
Thanks, Meenakshi. I hope all of you can hear me. Thanks also to Vineet for inviting me to be part of this event. As Meenakshi was reading that, I thought, that's a long bio and I should probably edit my bio. Will make it easier for us to get started. I've joined in earlier and I'm very happy to be part of this event. I think I joined in earlier to try and get a sense of the group and a sense of the discussions. And I can tell that many of you have real interest in constitutional law and have probably studied the subject both in the mandatory courses, and obviously you also have interests beyond what is taught in your courses, which is why you're attending this. So I thought a little about how to make a contribution to your ongoing workshop and what would be the best way to do this. My quick sense was, rather than giving you a overarching lecture, it would be better to sort of dive into some details. And listening to 2 short sort of interventions earlier today, I'm persuaded that that is probably the right decision, because clearly some of you have been following things quite closely and are very interested in these questions. So let me just say, and I think Meenakshi and Vineet have circulated to you this decision, the Balaji Raghavan decision. And I just want to explain a little bit of why I think it might be useful to think of this case in particular. Yeah, I see that this is a good forum where people are going back and forth, and I do want to keep that up. So I'll stick to my time of 20 minutes, and I've been told that we'll have a discussion round for 10 minutes. But I also see that this is part of an ongoing series of discussions that you're all having. So let me just say on constitutional foundings, what is important to remember, and some of you have been referring to Federalist Papers, what is striking about the Federalist Papers is that when the American founders went about drafting a constitution for themselves, they drew on whatever knowledge was available to them. Right? So there's a lot of reference to largely continental thinking. We also know that the thinking of particular intellectuals and scholars, John Locke's influence on the American Constitution is well sort of documented, but you also find references to other thinkers and scholars, right? Likewise, as we know, and I see that you've been reading Granville Austin's text on the Indian Constitution. So we know that the Indian framers were similarly looking at existing bodies of knowledge about constitution making and drawing from that. Right? So that's a fairly well-known sort of general fact. But I think the question is, why should one engage in comparative law? Because it leads one to also find sometimes very specific things that you can adopt. We are all lawyers here mostly. And this is a very important part of the evolution of law, whether in public law or private law. Some of you have done internships with law firms. When you go there, the idea is not that you start from scratch, right? So the phrase, you don't need to reinvent the wheel, is something that I think lawyers take very seriously. Right? So there's always a default format, and you start from that. It's often not very good to do that because the defaults are usually made by people for other contexts, other situations. But you say, no, I'm not going to reinvent the wheel. So I'll just take something and then work with it, right? And as you spend more time, you realize there are problems in that as well, right? So borrowing or transplantation or migration isn't always a good thing, right? And I think now there's a group of people, there are two comparative constitutional law scholars who brought out a recent book titled Abusive Constitutional Borrowings, right? So this is the work of Rosalind Dixon and David Landau, and they are pointing out that in earlier eras, so in earlier foundings, people used to look to other liberal constitutional democracies and try and borrow good things. But their point now is that the autocrats and the authoritarian leaders are also engaging in borrowing for what they call abusive ends, right? So that's more the trend that people are now following in the field of comparative constitutional law, and just to sort of flag that. But let's come to our context and see, how and why should comparative law be engaged with. So I will give you, some of you are making comparative references, but you're also making contemporary references, right? So this morning, as I was just reading the morning papers and thinking about, we're going to have a discussion about equality, right? The Balaji Raghavan case is about Article 18, which is part of our equality code. And why should one engage in that discussion? So I don't know how many of you, because you were coming in for a fairly early session, I hope you've had time to read the newspapers. If you haven't, I would urge you to read an op-ed by Seema Chisti, who I think is one of our most courageous journalists now. So she has an op-ed in the Hindu, today's Hindu. It's titled, "In India, the Steady Subversion of Equality." and Seema Chisti is talking about the systematic targeting of Muslims in contemporary India. Right? So she starts with the CAA. She refers to the laws that are called love jihad, but I think the proper characterization of these laws are anti-miscegenation laws. Right? So there's again there's a comparative context where many countries have done things like that. When we talk about anti-miscegenation, we think of the United States and cases like Loving versus Virginia. Yeah. So when we think about, so Seema Chasti is making an argument about what is happening in contemporary India. At the end of it, she ends quite poignantly, where she says, we must recognize the distance we have already traveled down the wrong path. And she says that may be the first step to try to wrest the descent into the darkness of an apartheid state, right? Now, powerful words, but I don't think that's an overstatement. I think many of us are deeply concerned with ongoing contemporary events. So sometime later today, the young Aryan Khan will be out on bail. It makes you really think about, if you have some understanding of the NDPS Act and how it's supposed to work. The great state of Kerala has given us Justice Krishna Iyer, who's famous for saying, bail, not jail. And when you think of this young man who has spent, more than 3 weeks in jail in the face of evidence that seems shaky at best, and there seem to be lots of questions, we have to think of these larger questions that these individual events are making us think about, right? So how do we think of equality? Obviously, to think of equality, and Seema Chasti's entire argument, apart from that and one of the things we are not doing is thinking of the South African constitutional founding and their great commitment to equality, right? So every society makes a commitment to an ideal in a particular way. And the point of making you read Balaji Raghavan, if you haven't read it earlier, was to also think about equality in a particular form. And why is it that the framers of our constitution decided to put in place in the Bill of Rights an important prohibition against titles, right? And obviously there are very particular local reasons for it. But even when you're thinking of responding to your own, you can look outward and think about what other countries have done. Right? And in this judgment, which the other reason for choosing Balaji Raghavan is because, again, it emanates from the state of Kerala. The first petition filed by Balaji Raghavan was in the High Court of Kerala. And if you read it carefully, it really came to unsettle a sort of consensus that these national awards were fine. By the late 80s, there was a general feeling that these awards were often being given to people who are perhaps not fully deserving. So there are a number of doctors who happened to serve prime ministers and presidents and were on the honors list every year. And people thought that that's a bit odd, and surely there should be some broad reasons for doing that. And I think they weren't seen as that controversial. So if you've seen the judgment, there were attempts even in Parliament to try and regulate the way these awards were distributed, right? But I thought it might be interesting to look at that founding period to try and understand why is it. So I was initially thinking I might just share my screen and take you through some of the provisions. But let me, the Indian Equality Code, but I just thought we'll quickly look at the American situation, right? So one important thing to think, it's also about different time periods and drafting styles. So all of you should be familiar with this. This is the 14th Amendment and Section 1. So what's interesting to see about different time periods is when the US Constitution is drafted in the late 18th century, we know it's a very short constitution. It was also one of the earliest ones. So the drafting style is also quite significant, right? So Section 1 of the 14th Amendment actually lumps together lots of things that later constitutions decided to separate out into different provisions, into different categories. So what is interesting about it is, for our purposes, it just says at the end, nor deny to any person within its jurisdiction the equal protection of the laws. So this is the origin of this guarantee of equality and this idea of the equal protection of laws. Right? And you know that Article 14 also borrows the same phrasing, right? And the same language is incorporated in Article 14 as well. So that's the interesting part. I won't take you through the other provision which is relevant from the US Constitution, which in the framers of the Indian Constitution drew from for Article 18.1, right? The prohibition against titles is mentioned, is taken also from the US Constitution. And in fact, a lot was made of the fact that the American Constitution also prohibits titles of nobility, but does not, cease from recognizing merit. And there are many American state honors, right? Whether it's the Congressional Medal of Honor or the Presidential Medal of Honor, where the US state recognizes merit, right? So that was one of the objections that Balaji Raghavan raised, that if you just look at the word of the phrasing of Article 18, it clearly mentions that no title should be given, and that's one reason for the prescription or prohibition of titles. Now, those of you who've read Balaji Raghavan will know that the Supreme Court, to respond to this question by Mr. Raghavan, had to engage in this originalist exercise. And it is actually surprising to me that why courts don't engage in that more often, because as we all know, we have a very vast record where we can actually find out why provisions have been put in, what was their intention, why is the phrasing in a particular way, right? So what's interesting for our purposes is that the court engages in that exercise and throws some clarity on why this was there. So some of you may have been watching Samvidhan. If you watch the episode of Samvidhan where the Advisory Committee on Fundamental Rights gets together, there's actually a mention of this. And of course, the subcommittee proceedings were not minuted. We know what they reached, but we don't know what actually happened. So there's some artistic license in the way Shyam Benegal shoots that particular thing. And one of the members of the committee takes a pot shot at Sir B.N. Rao to say, oh, Sir Benegal, if this comes into place, you might have to leave your knighthood behind, right? And so that's a nod to the fact that many people in the assembly also had titles, right? But there was, as the judgment explains, there was a reason why the framers wanted to put equality in a particular understanding, right? And wanted to make it clear that given our history during the colonial period, and those of you who followed that colonial history will know that in a lot of the colonial regime, really part of the reason it existed for as long as it did was it very often co-opted Indian elites, co-opted many of the large masses of India through various measures, right? And the nationalist movement really thought that this was something that should be stopped. So there was, if you see the debates, there was also a demand that all existing titles should also be abolished, right? Because these people have benefited from currying favor with the British. And I think it's Sardar Patel who says, no, a constitution is for the future. It's not meant to go into the past. So let's leave the status quo. But in the future, we need to recognize that there will be an incentive for people to get closer to government and for governments to try and co-opt people. So they didn't want that kind of practice to continue. And that's why there is the prohibition. So that's a very specific aspect. There are some debates about why Article 18 is included in the equality clause. Does it confer a fundamental right, or does it amount to a restriction? So in the US Constitution, for instance, the prohibition against titles is in Article 1, dealing with the legislative branch. It's not in the fundamental, not in their Bill of Rights. So we could debate why has it been included in that place? What is is it theoretically consistent? But I think that the message that they want to send out clearly was, and if you look at the Equality Code, there's the general proclamation of equality as a principle in 14, 15, and 16, then talk about how will that equality principle be manifested in non-discrimination, and then we know the debates about 15.4 and 16.4 of, you generally do not discriminate, but you also allow for affirmative action. Again, in the Indian Constitution, these are enshrined in the text of the Constitution. 17, of course, makes the clear proscription of the practice of untouchability. And then you get to 18, which says that this idea of a classless society also extends to the state not conferring titles, right? So what in the US Constitution is 4 words, in our Constitution then becomes broader. It becomes these 4 clauses. And if you go following Seema Chisti's nod, if you were to actually look at the text of the South African Constitution, you will find that being an even more recent document, one, the drafting style is very different. The South African Constitution, unlike the US or even our Constitution, was written to be read by ordinary people. So its language is very different, right? It's a very simple style, very accessible to regular people, doesn't have a very long legalese, and perhaps that's the model that is now contemporarily salient. And many people have also said that our constitution would be easier to access if its language and style were more people friendly, right? So in the South African constitution, that idea of equality has been expanded, and you can see that that idea is taken to a greater degree. So that's something to just keep in mind. I think I'll stop here. I'm at the end of my time. But let me just say that when I think of the founding period and how these two societies were responding to their particular context, right? So very often we talk about decolonization and post-colonial societies. The American Constitution was also one of the first post-colonial constitutions, right? So if you read the Declaration of Independence, you will see there is this great sense of wanting to move away from British practices. There's also, much like our constitution, there's a lot of continuity with that old order, but some things were very clearly departed from. And that's something that's very interesting. Some of you, if you're watching the T20 World Cup on Disney Hotstar, then I would also recommend to you a better use of your time might be to look at Hamilton. If you haven't seen the musical Hamilton, it's still on Disney Hotstar. And I think since so many references to Hamilton came earlier today, I would recommend to those of you who haven't seen it, because I think it brings to life in a very interesting way the words certainly of that time, right? in modern rap, which is a very interesting spin on American English of the 18th century, but certainly something that makes you think about it. And then when you watch it in that history in some ways comes alive, that period becomes more real. And then you also see that if we watch it, not just as people watching an American musical, but people watching it to say, how do societies, deal with big social, economic, and political problems, and how do they find a way out, right? Seema Chisti's claim that we are at an inflection point in our society, and if we don't act, then we may be getting into a very different era, which could be problematic. To me, seems like good advice. And I think societies don't need to think of it only at the times of founding, which would be the late 18th century in the US or the mid 20th century in India. The American scholar Bruce Ackerman talks about constitutional moments. And what he means by that is, of course, a founding is a very important moment in a society, but there are also other moments where you need to really think deeply about it. And none of us are framers of constitutions, but we are regular citizens with thoughts of our own and minds of our own to think about what is happening in the world at large. And I would say to you that if you take that spirit and say, as some of you are doing, what was Madison thinking? What was Ambedkar thinking? We can think as ordinary citizens and then act as our conscience urges us to do. And I would ask you to, adopt a framer's hat when you look at the contemporary world and say, how does this fit with values that we hold dear? Yeah, I think I'll stop here. I've gone a little over time, but we did start a bit late as well. I'm happy to field questions. I can stay on for a bit longer, subject to what the hosts have to factor in, as I'm sure there are other sessions as well. But thanks very much, and I look forward to hearing from you.
Thank you, Professor. We take questions first, if there are any questions from the students. You could even type it on the chat box and we can read it out.
I had a question with respect to the case, because the court goes at length to describe the whole debate and discussion in the Constituent Assembly, and then they cite a couple of constitutions from across the world. So there is this argument that Article 14 was inserted in a way to rectify the constitutional failings of American Constitution. So if that awareness was clearly there, that there is a provision in the US Constitution that says nobility, why wouldn't Article 18 expressly mention to nobility? There is no mention of nobility in there. So they were aware of it, but they didn't mention it. So how can the court go ahead and say they meant nobility and not titles or decorations in general, which does not really sit well with originalist intent, right? Because that is not what it says. And from the reproduction of the quote, it's not clear what they finally settled on with respect to what Article 18 means.
Meenakshi, should I just answer that first? Or do you want to take a few more questions?
No, you can answer that.
Okay, thanks, Mohammed. I think if you read it carefully, you will, I think this is an originalist exercise to the extent that if you see the narration of the way the provision makes its way from the Fundamental Rights Subcommittee all the way till the final adoption, there was a lot of emphasis on the people who proposed this were upset about hereditary titles. Right? So what's interesting is that the word hereditary is not there in the final version. So Sabian Rao, who, if you read the judgment, you also know that he was also, right from 1948, also involved in deliberations about these national awards, right? And how should they go? So he seemed very clear. In fact, the court cites a statement made by him to say that there's no bar against titles which recognize merit when conferred by the state. So what was the historical context? Again, I asked you to think about colonial history, especially those of you who are aware of the history of land in colonial India. So particularly in Bengal, the permanent settlement. So the British, it's not just, so the Americans are talking about nobility and peerage and peer systems. The Irish constitution also, which the court cites, very clearly says there will be no concept of peerage in Ireland, right? Because that's the way the British work, right? So you would give these titles, lords and knighthoods, which also pass on, from one generation to the next. So that's a great way to co-opt somebody. You give that person an incentive, not just for his or her lifetime, but beyond into future generations. I think that there's a particular way in England this continues. The Queen's honours are still delivered annually. And in British society, it serves a certain function and it works. But in colonial context, both the Americans and the Indians obviously found this to be deeply problematic. In India, and just to go in, so in India, in colonial India, we had titles like Rai Bahadur, Diwan Sahib. These were all titles given by the British, many of them were hereditary, and they went beyond the British titles that they employed. Right? So there was a lot of innovation and inventiveness in this, and many people in the assembly saw this as problematic. Right? So I don't think this is, if you just go by, so they derive something from the American example, but nobility doesn't find mention there because they were not particularly worried about what the Americans were worried about. They were worried about these particular titles that the British had generated and created in India. So I would say this is an originalist exercise, and it seems, if you are familiar with this question of can Constituent Assembly debates be cited by the bar and in judgments. There was some debate on that in the early years. It's only around Kesavananda, about a quarter century after the Constitution, that it became legitimate to refer to Constituent Assembly debates and cite them, right? So Balaji Raghavan is, I think, one case where they look at that. I think we can have different views on whether the court gets that originalist interpretation right or not. But at least my reading of it is they broadly understood what, and there are these copious citations to several people who spoke on this issue, either in the subcommittee or on the floor of the assembly. Right? I think your latter point of did they resolve it? Clearly, they didn't resolve it well. Right? This issue. So if you read the majority judgment of Justice Ahmadi, there was some reference to, oh, this is clearly a distressing situation. We allow them to go on. They also put a further spin on it, right? So this is not just an originalist exercise. So they say, yes, anything that has can be used as that has a hereditary connotation will not be allowed. But they said the Bharat Ratna and the Padma Shri and the Padma Bhushan don't have that character in themselves. But they say by the 90s, we see that a lot of people, and this happens, even today. Last week, there was an obituary in the Deccan Herald where somebody was mentioned with Padma Shri, right? And so the court tries to look at that practice where people and it's sometimes not the people themselves, it's others who want to invite somebody and they say, this person is a Padma Shri awardee, and you add that to an invitation card or a wedding card and put that in. So the court really wanted to indicate that it frowns on that practice and adds its own embellishment to the originalist practice, no hereditary practice, right? So there's a little bit of creative interpretation on the court's part, but of course they do nothing to implement it. Right? And think also, this is the mid-90s, the forms of implementation that the court came up with at that time and in other cases, the court did not use in Balaji Raghavan, right? Though if you read Justice Kuldeep Singh's concurring judgment, he wants to go further, and he's actually much more sharply critical of this practice. And he says there should be a committee comprised of so many people who will, look into this and follow. But again, the court doesn't give you an avenue to come back. So if you think of the Pegasus ruling now, what is interesting is Chief Justice Ramana has posted the matter 8 weeks from the time that the order is given. So there's this idea of continuous oversight that is clearly missing in Balaji Raghavan. And perhaps that is why 25 years later, our national awards are still subject to the same charges that Balaji Raghavan raised in the early 90s. Yeah. Okay, I think I'll stop there unless Mohammed has a follow-up.
I think we're running short of time as well, so we may not be able to take in more questions at this point. So if you do have any questions, do write to us. We'll see if we can communicate them to Professor Thiruvengadam and if he could respond to some of them. Other than that, I think we can close the session with that. Thank you so much, Professor, for joining us. It was interesting that you said that often autocratic leaders are using comparative law to sort of, in an abusive manner, but it could, what we see is sometimes even originalist positions can be used in that manner. For instance, for instance, we do see claims of suddenly the rise of the reference to Ambedkar claiming that Sanskrit should be the national language. So we do see that sort of co-option in the political sphere of originalist positions as well. So that was very interesting for you to point out. I think that's about it. Thank you all for joining us for this session. We will log in for the second session at 11:45. We'll reconvene then. Thank you so much, Professor. Thanks.
Thank you. Thanks very much. And I wish you all continued robust discussions about all these important issues. Thank you. Bye-bye.
Thank you, Dr. Thiruvengadam. This is Usha here from Chennai.
Hi, Usha. Good to see you again.
Yeah, really. It was so great. Excellent session. Very engaging. Thank you once again for your session.
Thank you. All the best. Bye-bye.
Welcome back, everybody. We're going to start session 2 on freedom of speech in US and India. Kalyani, could you share the slides? Yeah. Thank you. So in this session, we will similarly divide it into 2 parts where we will do a summary of readings for, say, 10 minutes, followed by a Q&A for 5 minutes. And then we will have a student discussion. Then we will move to reading set 2, where we'll again do a summary of readings for about 10 minutes. We will have followed by a Q&A and the student activity. Once we're done with the 2 reading sets, we will have Professor Sitaraman Kakarela from the Professor Azim Premji University to give us his remarks. And then we will close this session. So this is the broad outline for the session. Anybody have any questions? Right, I'm assuming there aren't any questions on this, so we can start with. So with freedom of speech, I thought it would be interesting to start with just looking at the provisions in the 2 constitutions itself. So we'll start with the American Constitution. So as you all know, as we discussed, the freedom of speech provision was included in the Bill of Rights, the First Amendment, and found itself into the Constitution in 1791. It states, and I'll read it out, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So there's no standalone freedom of speech clause. Similar to our Article 19, it's clubbed with few other civil liberties. So what does this provision mean? We had a reading, a small explanatory note rather, that we had shared by Jeffrey Stone, in which he breaks down this provision itself. And the first point he highlights is, what does it mean when they say Congress shall not make law? What does this Congress entail? It's not just the legislature, it's all government agencies and officials, of the federal and at the state local levels. And this is important because it only prohibits these government agencies from making any laws, not private individuals and organizations. So you could have private individuals and organizations that have policies that would sort of hamper the freedom of speech. The second thing he discusses is, what does the term speech and press itself mean? He states that it's not just talking, it's talking, writing, printing, broadcasting, using the internet and other forms of expression. The sort of expansion of what speech means and what it entails has come through judicial opinions. And the third thing he discusses is, so there is a sort of presumption of unconstitutionality of laws that curb freedom of speech. There are exceptions to this presumption. And when we look at this exception, we look at two kinds of speeches. First is speeches that are protected under the First Amendment, and speeches that are not protected. So in the unprotected category, there are two broad kinds of sort of regulation that he highlights. One is content regulation, and the other is non-content regulation. So non-content regulation of speech is essentially regulation that doesn't determine what should be or does not say or deter what sort of content can be spoken, but rather says things like, okay, this is a no noise zone. You cannot speak here. You cannot have public meetings here, because this is a hospital zone. You cannot use regulation of decibel levels to curb noise pollution. These are forms of non-content regulation, which is permitted under the First Amendment. And when it comes to content regulation, there is two forms of content regulation that is permitted. The first one that he discusses are exceptions, or sort of what the court calls low speech. And there are 5 categories of this. It's a little more: defamation, obscenity, truth, threats, fighting words, child pornography, and commercial advertising. So when it comes to defamation, is making false statements in a way to disparage a person's image or reputation. This is considered unprotected or low form of speech under the First Amendment. Obscenity, anything that is highly sexually explicit content, hardcore pornography, is considered obscene and unprotected form of speech. True threats are incitement words or words that incite violence. Fighting words, once again, similar to true threats in the sense it has face-to-face, like personal insults that are likely to lead in an immediate fight. These are, once again, low speech or unprotected speech. And pornography, child pornography is unprotected. And commercial advertising, there are laws that sort of regulate misleading commercial advertisements are considered unprotected forms of speech. So this is the broad framework. So when it comes to these unprotected categories, the presumption of unconstitutionality of laws sort of fades away, and then you do discuss, then you would have to prove that you do have that it does not fall within these exceptions. So this is broadly the American context. Now I will move to the Indian framework. So we have Article 19, which states among a bunch of rights, the first one is, all citizens shall have the right to freedom of speech and expression. And there's a restriction embodied in the clause right after, which says, Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interests of sovereignty, integrity and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation with contempt of court, defamation, or incitement to an offense. So to just look back at how we came at this provision, if we go back to the draft constitution, we had draft article 13, which is what we see now as article 19, which states that similar to what we have with the freedom of speech and expression, it's just the restrictions are narrower and do have some grounds which we don't see now. For instance, it says that that there can be laws that prevent this that relate to libel, slander, defamation, sedition, or any matter which offends against decency or morality or undermines the authority or foundation of the state. So let's look at what the Constituent Assembly debates were on having such restrictions in the Constitution itself. So the restrictions, if you see in the draft article, as I highlighted, were libel, slander, defamation, sedition, or anything which offends decency or morality or undermines the authority. Now, the discussions primarily in the assembly revolved around these restrictions that were placed on the freedom of speech. Now, some members felt that rights cannot be absolute and there must exist limitations on them in certain circumstances. But others felt that, these restrictions would actually negate the enforcement of the freedoms guaranteed. So just to highlight some of the members who opposed these restrictions, Damodar S. Seth had actually said in this assembly on 1st December 1948, he said, "Sir, to suspend civil liberties is tantamount to a declaration of martial law. Even in the United States, civil liberties are never suspended. What is suspended there in case of invasion or rebellion is only the habeas corpus writ. Though individual freedom is secured in this article, it is at the same time restricted by the will of the legislature and executive, which has powers to issue ordinances between sessions of the legislature almost freely, unrestricted by any constitutional provision." He states, and I quote, that even in the even in the US Supreme Court, where they do have the doctrine of police powers, they've permitted the state to limit civil liberties, where they've permitted the state to limit civil liberties directly. We have to carefully study the law of police powers in the United States. It would be clearly seen that the limitations embodied in the draft constitution are far wider than those provided in the United States. He says, under the draft constitution, the law of sedition, the Official Secrets Act, and many other laws of repressive character will remain intact just as they are. Another member who opposed these restrictions, Sir Sardar Bhupender Singh, on 2nd December 1948 highlighted, "What is being given by one hand is being taken away by the other. Every clause is being hemmed in by so many provisions. To apply the existing law in spite of changed conditions really amounts to trifling with the freedom of speech and expression. From the very beginning, we have stood against the existing laws, but now you are imposing them on us." There were some members who felt that these restrictions were needed as well. For instance, Seth Govindas, in response to these allegations, said, "I would have myself preferred that these rights were granted to our people without the restrictions that have been imposed. But the conditions in our country do not permit this being done. I deem it necessary to submit my views in respect to some of the rights. I find that the first subclause refers to freedom of speech and expression. The restriction imposed later on in the respect of the extent of this right contains the word sedition. An amendment has been moved to remove this in regard." So certain points that he raises are, maybe we can remove some of these restrictions, but it is still necessary to have restrictions. And so what they did do is they removed sedition as a permissible restriction under clause 2, and they also added contempt of court. Subsequently, this was amended, thing I forgot to highlight is after these discussions, they also felt the need to say maybe a balance should be struck between these two views of saying no restrictions at all and having restrictions. Is they introduced the concept of reasonable restrictions. This amendment was also passed in the Constituent Assembly. So Ambedkar, who interestingly, a lot of these conversations, they said, oh, in the US, the fundamental rights are absolute, the freedom of speech is absolute. Why would we have restrictions? To which actually Ambedkar responded, and he said that actually fundamental rights are the gift of the law. Because fundamental rights are the gift of the state, it does not follow that the state cannot qualify them. Further, he clarifies saying that in America also, the fundamental rights are not absolute. He in fact refers to a case, Gitlow versus New York, and he states, he quotes from that, says, it's a fundamental principle long established that the freedom of speech and of the press, which is secured by the Constitution, does not confer an absolute right to speak or publish without responsibility, whatever one may choose, or an unrestricted and unbridled license that gives immunity for every possible use of language and prevents the punishment of those who abuse this freedom. So Ambedkar says, counters these arguments by stating that while your argument that in the US that the fundamental rights are absolute is also mistaken, and that there are restrictions on this fundamental right or freedom of speech. So this is just to give you a context of what these provisions are and what to give you a context of how they came into being, what they stand for, and what we see them as now. And so I would probably pose the discussion question first, and then students can, if they have any questions, you can ask me. The first thing, so the discussion question we have here is a hypothetical, and then I have a question, and then it's open for students to answer this question. Yeah, so this hypothetical is a campaign to oppose moral policing was launched called Love on Streets. As a part of this campaign, many people engaged in public displays of affection, kissing and hugging their partners. Participants were arrested participants in this campaign were arrested, and these participants claimed that the arrests were in violation of their freedom of speech. Discuss whether the acts of the participants are protected under the US and Indian constitutions. So any questions at this point? If there are no questions, then we could open the floor for discussions. And if you want to take about 5 minutes to think through, or 2 to 3 minutes to respond it over, that's fine too. And then anyone can take a stab at it.
Could I share my opinions?
Yes, please, Naveen, please go ahead.
So I feel that under both the US Constitution as well as the Indian Constitution, like this arrest won't be sustainable, because under the US Constitution, that is the First Amendment, there's a positive obligation cast on the state to ensure that freedom of assembly and freedom of speech is upheld. So therefore, there's a positive obligation on the state, and therefore this act would be in violation of the First Amendment. And even in the Indian Constitution, Article 19, it's a negatively worded right. So there, the state should ensure that no such violation should take place, irrespective of them making a law like that. That is definitely prohibited, but they should not be upholding any kind of act which would be infringing upon the rights of other people. And since here the state, that is the police machinery, is engaged in arresting these couples for public display of affection, they are infringing upon the individual rights of people. So that's a violation under Article 19. So therefore, I don't think that this arrest would be sustainable under both the US and the Indian Constitution.
Thank you, Naveen. Anyone who has any responses, wants to add something to it?
Adding to the position in the US, although one may argue that it would amount to obscenity, it was also provided that obscenity in this case would only be when there's hardcore, highly sexually explicit pornography, which in this case I don't believe this amounts to. So I think they would still be protected under their freedom of speech and expression.
Thank you, Sneha. Could maybe you, when you're responding, or think about how the texts of the provisions are in the two constitutions and compare that itself and see, based on the text of the provisions, how they would view this.
If I may just add, my name is Anita. I think the only contentious sort of aspect in the Indian provision that could potentially apply to this is public order, decency, and morality, which in itself is a very flimsy ground. And if we were to draw a parallel, I think something of this sort did happen 4 to 5 years ago, where there were Kiss of Love protests in groups, especially in the state of Kerala. I think some of us might remember this. And I think when it went to court, the characterization was that this would not come under those exceptions, but I don't remember the judgment. But that being said, I would agree with the characterization that the others gave, that it would not come under the provisions both in the Indian context as well as in the US context.
Thank you, Anita. Any other responses?
If I may add on to what Anita just spoke about. So if we are applying the community standards test, which is what was given in the reading material, as well as what we see in India after Avik Sarkar's case, when we do apply it, if it is with regards to India, then it might be a problem because it is not exactly whether it would pass community standards is a question. But given the active role of our judiciary, I believe that the answer would be that they would perhaps state that the judiciary needs to intervene to a certain extent, and that the protest wouldn't be seen as obscenity, or it shouldn't be considered as obscene. And with regards to the United States, we know it's fairly liberal when it comes to free speech, and especially in the amendment as well. So the protest may not be a problem there as well. But again, the question remains of where would the protest be? Would it be in a more conservative area where this is done to ignite tensions between certain groups? Then that again could be a question. But then again, it shouldn't qualify as obscene, but it would remain with the judiciary to perhaps think about it in a different manner.
Thank you, Megha. Maybe one thing we could think about is, especially since we went through the Constituent Assembly debates on whether we should have restrictions or not, is if you could even comment on that. Do you think that the Indian Constitution, which has inbuilt restrictions in it, do you think that sort of framework works? What are your opinions on having such a framework?
Yeah, so to answer this question, this was discussed in one of the reading materials which were shared, wherein it was said that, I think it was Ambedkar who was discussing this, wherein he said that in US, the fundamental rights are not completely absolute, but they're worded in such a way. And later on, the judiciary gives the Congress, that is the state, some kind of police powers to impose reasonable restrictions on these fundamental rights. But in India, the fundamental rights in themselves put restrictions upon the fundamental rights. So therefore, I think that difference was brought out. I think the latter structure, that is the Indian Constitution, where the restrictions are expressly laid out rather than being open to judicial discretion or the discretion of the legislature, is much more better.
Thank you, Naveen. Anyone else who have any thoughts on this?
So I just had a question,
Yes.
for you could answer it, or anyone else who has an opinion about it. So like recently there are these concepts of white free zones in US university campuses, and that's on both like state run as well as private institutions. So I just wanted to understand whether that would fall under the exceptions that you mentioned under the US First Amendment.
So I'm assuming you're talking about safe spaces on campuses for people of color to discuss. And yeah. So I would probably ask students to comment first, and then I'd probably give my thoughts on it after, if that's all right.
If Naveen or the host could clarify what exactly is a white free space, then that would help.
Yeah, sure, Megha. Maybe from what I understood is that some campuses have either hostel spaces or student spaces where which are called safe spaces, and where people of color have meet, have discussions, and people and white people aren't permitted to enter those spaces. Just to give you that sort of context. Yeah.
And the question was, would this be considered against public order?
Yeah, the question is
whether it would fall under the exception to the First Amendment. Like we had a bunch of exceptions, right, which was discussed in the presentation. So I just want to understand from a constitutional perspective only where this falls.
All right, got it. Thank you. If I were to give my opinion on that, I'd say that it would fall within the ambit of free speech, because as long as the community doesn't incite violence or hatred or ignite terror or anything of that sort, because then it would be seen as more of a collective of people who are gathered with a certain idea or a certain interest or certain experiences and so on. So there wouldn't be a intelligible differentiator per se if we say that groups of persons of color gathering together and discussing or engaging in activities together is not free speech. So I believe that it would be well protected by free speech.
Any other thoughts? Megha, I think maybe this way to look at it is that you're looking at it from the perspective of the people of color's freedom of speech. I think what Naveen meant was, are you infringing on the right, the freedom of speech of white people to come and participate in such discussions?
And in that case, I don't think that would be the case, because there can be such discussions where white people are also involved. It just so happens that there is a specific space for people of color to discuss it as well amongst themselves. So it's a matter of choice, again, which doesn't cause any harm. So there doesn't seem to be a reason why it should be considered as excluding a certain group and that causing terror. That's a bit of a stretch, according to me.
I see. My question was not on moral grounds. Like on moral grounds, we could justify any kind of situation. But my question was like strictly with regard to fundamental rights, like the First Amendment and freedom of assembly and freedom of speech, which is given under the First Amendment.
Well, Naveen, I think maybe I'll just tell you what I think about this, since maybe then we can see what responses are. Obviously, the distinction between a state university and a private university is there. So in private universities, we know the First Amendment would not apply. So in that case, that they could have certain white free zones or safe spaces. But coming to state universities, then strictly speaking, without evidence to show true threats and fighting words are the two exceptions. One, true threats is that there's a likelihood that there would be a crime that's committed, and second is that face-to-face personal insults are likely to lead to an immediate fight. So what we can think about is maybe loosely you can use fighting words to say in these spaces that there could be certain things triggering that are said, which could, or insults that are made, which could lead to an immediate fight, and therefore it should be prohibited. Other than that, I do not think that it would fall within any of the other exceptions, and may not be, such laws may not be protected, or such policies may not be protected.
All right, thank you.
If anybody else has any alternate first viewpoints on this, or who want to comment on this, add to this, please feel free to. We can actually, this is a good point for you to keep in mind also, to ask the American students when we have the interactive session today evening. So it's something you can discuss with them as well. Any other points, any other thoughts on the text, on the hypothetical?
I think there are, when you, in this particular hypothetical scenario, it's wrong to characterize it simply as a matter of free speech or expression. What is actually at stake is a bundle of rights. You also have a right to assemble freely. You also have a right to, express, which may overlap in this case. So, the state could always say, we are doing it under obscenity, but you could say, we're just assembling. So there is a certain degree of difficulty in reconciling where the restriction is and if the restriction is valid at all. Like for instance, when you refer to morality under Article 19.2, the understanding we have today is that it's constitutional morality and not the morality of what majority perceives as, repulsive or unacceptable. So there is a bit of difficulty in characterizing it as simply a matter of free speech or assembly, because two rights namely intersected in this particular case.
Thank you, Mohammed. Anyone have any responses?
Yeah, that's fundamentally, like, I think, dependent on the language that is used, like in framing that particular provision, because the First Amendment encompasses everything, like freedom of assembly, freedom of speech under just one provision. But in India, it is different under different provisions. So I think that bundling or not bundling off, it would depend upon which constitution we are referring to.
Thank you, Naveen. Anybody else? Okay. Since there are other thoughts, you want to put them on the chat, please feel free to do that. We'll probably then proceed to the next reading set.
Thank you, Meenakshi.
I'm just going to share the slides.
Yeah, I could do that. So for the second part of session 2, what we're going to be looking at is freedom of speech, but more particularly to case laws, which relate to obscenity and how the courts have viewed it, and this is in relation to publications. So the first case that we will be looking at is Grove Press versus Gerstein, which is a 1964 case. And in this, the court is looking at a ban on a book titled Tropic of Cancer by Henry Miller. And it is actually one of the most censored books in history because of the kind of sexually explicit content that it has in the book itself. So in this, really the court actually hands down just a single para judgment, but where they say that we are striking down this ban on the book because of our reasoning in another case, which is Jacob Ellis versus Ohio. In this, the argument is that the ambiguities of the obscenity test in the case Roth versus United States, which I'm sure we've also covered, can be invalidated if the Supreme Court establishes obscene only those communications which are utterly without any redeeming social value. So they sort of separate the idea of certain things which have no social value as being obscene, then those can be removed from the classification itself. And this is the phrase utterly without redeeming social value, is a phrase that makes its way into the case and is also hailed as a revolutionary doctrine. And what the majority, a narrow majority really accepts, is that although of course there are sexually explicit scenes in the Tropic of Cancer, the book did have literary merits, right? And it wasn't without any social value, and so it separates them from other materials and that are actually deemed to be obscene and strikes down the ban. What is also important to note is that the US now uses a Miller test to classify what would be obscene, which was determined through a case called Miller versus California, which is a 1973 case, which is much later than Grove Press versus Gerstein, where they classify something as obscene after taking into consideration community standards, and they look at community standards through the perspective of an average person. Then they look at if the work depicts or describes in a patently offensive way certain sexual conduct. And lastly, they see if the content as a whole, if it lacks serious literary, artistic, political, or scientific value, which is similar to what the court holds in Grove Press versus Gerstein, because they say that the literature itself has certain merit, and so it can't be considered as obscene, and the ban was struck down. I will quickly take you through both the cases because I think it sort of lays the foundation for the activity that we're going to show you after the two cases. The second one is the case of Perumal Murugan. Thank you. Right. So over here, of course, the Indian Supreme Court is looking at the book called Perumal Murugan, and it was a book that was released by Perumal Murugan. It's called Matoru Bagan. I might be pronouncing it incorrectly, but it was released much before the controversies around it started. And it describes the travails of a childless couple and the social stigma around it. And certain parts of the novel describe this historical temple, the chariot festival, and also names particular towns in Tamil Nadu. And it describes these places as one where rules of sexual conducts are sort of relaxed. And there are a lot of intermingling between, adultery, intermingling between partners, and a lot of sexual activity irrespective of people's marital status. And so much after the book was released, the local authority or the administration form a peace committee, and they order the author to issue an unconditional apology. And separately, multiple petitions were also brought to the court seeking criminal action against the author. So over here, the court shows concern over the state's management of the situation. So what the court really does is it states that in cases where there is certain material that could be sexually explicit, if it isn't considered as obscene and it is a right to the author's freedom of speech and expression, then it is the state's obligation to ensure that law and order is actually prevails. And so over here, the court noted that the community standards test, which is also followed in India, suggested that the novel was not in any way obscene. So it wasn't obscene as per community standards. The novel didn't appeal to prurient, which is sexual interests of individuals, but described the emotional travails of this childless couple. And they also noted that those who are objecting to this particular book don't have to read it. And banning a book merely on the grounds that it offended certain people is never the solution. And the court also, of course, considers the question of obscenity and says that it should be viewed on the basis of how it is perceived by the society at large and not a particular group of people. And the fact that the book actually received numerous awards also talks about its social perception. And we know this because the book was actually out in public for a long time before the townspeople and the community actually took matters into their own hand. The court then also said that the petitioner's contention that the novel didn't seek to represent the practice as historical truth and are actually based on and sort of suggests that they're based on folklore. And he says that, and the court then says that the action against the author was not warranted. So again, here the court upholds the author's right to freedom of speech and expression and states that anything that the peace committee had said was not binding, and that it was the state's duty to protect controversial speech, and such committees should not violate the right of freedom of speech and expression. So that's just a quick run through of both the cases. We can now quickly move on to the activity because it takes from the cases. You can look at, I will give you a background to the activity as well, because I'm not sure how many of you have actually read Lihaf, which is a short story by Ismat Chugtai. Have you covered it in your syllabus by any chance?
No, I don't think so.
Thank you, Anita. Great. So then I'll just give you a background about Lihaf. So Lihaf is written by Ismat Chugtai. It's a short story in Urdu, which is actually translated in 1942. And the story is written from the point of view of a small girl who is the niece of the protagonist in the story, which is Begum Jan. And the story starts with talking about how Begum Jan is married to a Nawab, and the Nawab has multiple encounters with other male members. And so Begum Jan is left to herself and she has a very depressing life after marriage. And Begum Jan sort of starts to wither. And that's when the other character in the story comes into play. And her name is Rabu. She's Begum Jan's masseuse. And she is called to Begum Jan's place every day. And you know, they sort of, Ismat Chugtai takes us through the way that Rabu sort of massages Begum Jan in a not very explicitly obvious way, but it tends to insinuate that they're having a sexual relationship or a hidden relationship of sorts. And this paragraph that we've picked up is a paragraph where the niece is watching something that's happening between the two of them under blankets. And she is describing it, and because she is made to sleep next to Begum Jan's bed. And what we would like you to do is see if, after we saw the two case laws, to see if when you apply the two case laws as well as the kind of provisions and laws that America and India use for obscenity and freedom of speech and expression, if this particular short story would then be obscene, considered as obscene. So you guys can take maybe 2 minutes to read the paragraph, and then we'll wait for any questions we have. And again, maybe we could divide you into two groups where one looks at it through the Indian perspective and the other looks at it through the American perspective. And sorry, just a clarification, the Perumal Murugan book is actually a Madras High Court case, not a Supreme Court case.
Can I ask a question with regards to the Perumal Murugan case?
Of course.
So you mentioned that the judgment had stated that it's not an issue because the readers can choose not to read the content and it won't be considered obscene. isn't that a rather dangerous precedent to have? Because there can be situations, let's say, for example, portraits of child pornography, and that again, people can choose not to see that, but it is still morally repugnant. So how can you, I guess, address?
Yeah, I actually agree with what you say, and I also think it's important to see it as a whole and not just as that particular line. Maybe read the judgment as a whole, where he also says that it's not just about the people who choose not to read it, but also the fact that the society at large wouldn't actually consider it as obscene. But I think I'm going to pause on exactly what I think and let this be a question for the discussion as well, because I think it would come into play when you look at Indian provisions and the Indian law, and to decide if even Isma Chuktai's portion or paragraph would then be considered as obscene, if that's okay.
Yeah, sure. Thank you.
I hope, I mean, if you feel free to take screenshots of it before we move you into break rooms, so you can use specific statements if required, or anything else. Meenakshi, maybe we can move them into break rooms now. Is there any other questions that anyone has?
Otherwise, you can always come back and put it in the chat box if you do have any questions while you discuss. So I'm going to break you into the same groups. I hope that's fine. So I'm just going to open the room out. Yeah. Yeah, I think all students are back from the breakout room. Kalyani, you want to take over?
Would breakout room number 1 want to start with putting forth their views on what they think, if they think the paragraph from Lehaf would be considered obscene as per the American provisions, I believe.
Yeah, hi. So I believe that the paragraph would not be obscene. So for that, we have 3 points to raise. So primarily, it's the community standards Miller's test, and third one is the entire movement towards pro-LGBTQ. I'll just elaborate on all 3 of them. So primarily, the community standards test, in that like the present overly liberalized society that we live in is more open to such practices. So the community as a whole believes in like being more expressive about sexual thought and content. So therefore, the court could look into the contemporary society and uphold that. So the community standards test would be the Miller's test basically speaks about protecting literature which has extreme academic and literary prowess. And this is one such case wherein like a sexual act has been described from the point of view of a very small child in a very different way. So I think we personally believe that it's a case of extremely high literary prowess. So therefore it satisfies the Miller's test as well, and therefore it won't be banned on the grounds of obscenity. And thirdly, like there has been a lot of legislative movements to decriminalize homosexuality and pro-LGBTQ, and strictly speaking, from like it has been decriminalized, and there are no state interventions into LGBTQ people, so and their lives and their choices. So from that perspective, I think previously there's always been a link between obscenity and criminalization. So and that used to add on to the concept of obscenity also. So these practices, when they were criminalized, would be viewed as more obscene if they weren't criminalized. So now that that's out of the question and it's been decriminalized, that aspect also has been reduced. So the entire concept towards this article being obscene would not stand. Therefore, it can be published.
Thank you, Naveen. Else from your group that wants to add?
I think Naveen's covered everything we've discussed.
Awesome. Then maybe we can move to break room number 2 and see what they think.
Yes, so the question is whether that paragraph would amount to obscenity. I don't think it would, because firstly, it's just a paragraph. So there is very little to go by besides, what is there. And it has been long established that you cannot pick and choose from a book. You have to read the book as a whole. Only after that you can say whether it's obscene or not. Even then, these days, the standard is that it must absolutely lack in any literary merit or any merit at all, which is not the case with most work. You could ascribe some level of literary merit to most works, and the author in question is pretty acclaimed, so you really can't say it's not a work that is lacking in literary merit and is obscene. So firstly, there is nothing to go by to determine obscenity here. Mere reference to sex or sexual conduct does not really render anything obscene. That would put a lot of literature at risk. So by that simple logic, I do not think it's obscene.
Those are fair points. Anybody else?
So we, like, from group number 1, we were also discussing the Indian position, like, to a certain extent, because we had some additional time. So we, like, brought up a couple of points about how this could have been held to be obscene if it was pre-Navtej Singh Johar, because this was technically referring to the judgment. It would be these acts are decriminalized, so therefore that amount of obscenity would also come down. But also, having said that, we also want to raise that there's been a lot of literary works which have been published pre-Navtej itself. So we were discussing the works of Manto, wherein he has a lot of references to lesbian activity and other kind of LGBTQ stories in his short stories, and these have been published long ago. So I think strictly from constitutional perspectives, like not even taking obscenity into account, like these things have been published from before, like previously as well. So I don't think it stands the test of obscenity.
Mm-hmm. I actually have a question. When you speak about the judgments that we have, especially when you mentioned Navtej Singh Johar, is there, do you think it's necessary that law dictates community standards?
Law didn't dictate community standards. Maybe it could correct it to a certain extent.
So you're saying it would be an added value in a sense to the existing community standards?
I think it's from my perspective, like the law shouldn't decide what the community should think or should do or they should not do, but the choice of the individual should be upheld. Therefore, the law just needs to ensure that nobody's rights are infringed upon, but only to a certain extent. Like as long as it doesn't infringe upon, like one person is not infringing upon the rights of another, the law like needs to draw the line over there.
Okay, thanks, Naveen. Anyone else? What's sorry, something interesting from what Mohammed had actually said is that I completely agree when you say that you need to read particular texts in context of the entirety of it and how they've been written. But actually, the Lahore High Court did try Ismat Chugtai for obscenity in behalf. And what's interesting is that one of the arguments was not that the entire text was sexual in nature, but the use of the word ashik itself was what was obscene. And she actually has another piece called The Trial, where she describes her and Manto's trial in front of the Lahore High Court for their work being obscene. So it's interesting that we do think and we agree that you can't read a paragraph in itself, but you need to see the context of it. However, she was in fact tried for just the usage of one word being obscene or being too sexually explicit. And it wasn't even what we would consider a very sexually explicit word. So yeah.
I think just to add on to it, we have parallel in India with Justice Hidayatullah, who upheld ban on Lady Chatterjee's lover. So judges make these sort of mistakes, but the consensus seems to be that we must read a book as whole and not pick lines from it.
That's right. I completely agree. Maybe we can give another minute to see if we have more comments and then move on to the next part if we think that we're all agreeing with the fact that neither of the constitutions would in fact deem the paragraph obscene.
So one doubt that we had was whether when we talk about community standards or the Hicklin's test in general, should we think of it in the time and place in which the said publication took place? So in Ismat Chughai's case, it was published in India and we were discussing it from the US context, and it was published in a time where this was shocking and this was very problematic. So just in general, when we're understanding these tests, do we always contextualize it to the time and place, or is there some sort of objective law legal standard which will be the same across time? Is there something of that sort, or is it always?
Before we answer, would somebody else want to take it? Somebody from the students.
I don't think any student will respond. In that case, maybe I'll take a stab at it. I think that it will be context specific. It will depend. So when the court is hearing a particular matter, they will look at the community standard test, apply the community standard test based on the time and context of that time. And I think that will definitely have a bearing. You're trying to look at how the community as a whole, or a reasonable person belonging to that community as a whole, views a particular a piece. And in that case, yes, the time would definitely play a role.
Yeah, I actually agree with what Meenakshi said. And just to, with Ismat Chughai's book, where none of the rest of it was actually thought of as sexual content, because they didn't read more into it. They didn't read it in the way we're reading it right now. Even in the trial, they don't talk about this particular scene as being sexual, which is why they picked on the word ashik. Maybe they didn't know it was sexual, but they didn't want to highlight that. So yeah, I feel like time definitely, and the way the community changes would of course have a huge bearing on how courts decide cases, for sure.
Doesn't the word ashik just mean lover? Like
exactly.
How
yeah,
exactly?
that's the entire point. So
I think it's a phraseology that was used was collecting ashiks. So they found that a woman collecting or a man collecting ashiks or multiple lovers was something that is obscene.
Yeah. And the argument was exactly that the word ashik is used in so many poems, in various literature works, in songs. So how can you deem something that's used so regularly as something so sexual? Which is why I think they then said that it wasn't obscenity.
Going back to actually one of the points raised by the students earlier before we broke out, which was about the sort of distinguish between child pornography and a book publication which has a sexual explicit scene. And when courts say things like, if it's offensive, don't read the book, how are you going to counter instances where there is a portrayal of child pornography or violence? So I think that's something that's we should discuss. We have time to discuss. So if anyone wants to respond to that, please feel free to.
Yeah, so I think in this concept, I think we should not just look at it from a moral perspective, because child pornography, when say it is being recorded, it infringes upon the rights and free will of the child that is being recorded. I think there's a larger social evil that is being corrected when child pornography is being banned. Like the ultimate end product has been banned so that the means which infringe upon the rights of other individuals, which are children who cannot give consent, their rights are not violated. Therefore, child pornography is banned. But I think obscene literature as a whole, like when arguments are raised around it, it would just be like, you could choose not to read it as well. Like if there's a book on which contains obscene literature lying there, it doesn't infringe on my right or the rights of the author or the rights of anyone. It's just a fiction of the person's imagination. So therefore, I think that's where we need to draw the line of distinction.
Thank you, Naveen. Any of the other students have any comments?
I'd like to slightly disagree with Naveen there. So you say that it's a book and they can choose not to read it. There have been many instances where people have been very much influenced by books. And if you even look at Hitler's case, Mein Kampf did get a lot of people invested into his ideas. So when it comes to child pornography, yes, for videos or such, that does harm the child involved. But even portrayal of child pornography in a positive sense that can be seen with the internet, unfortunately, but once you get that into books as well, that can also negatively affect the society. So I don't think the argument of you can choose not to read it stands there, because the people who do read it might cause harm, and that is something that should be looked into.
See, the concept of hate speech comes into play when you're referring to, say, Mein Kampf or something. The entire scenario and the laws under which we'll be banning, say, Mein Kampf would be different from, say, obscenity. Like I just brought up the concept of you could not choose to read it with regard to obscene books. Other books, like, regulating other kinds of speech is a completely different spectrum which can be dealt with under other laws and other fundamental rights.
If I could come in here, there is a interesting case, Ashcroft versus Free Speech Coalition. So in that case, the US Supreme Court struck down a provision that dealt with child pornography. So the reason that they struck it down was that it was overboard and it restricted free speech, even though it dealt with child pornography. So we have to really think about why we are banning child pornography here. Is it because there is something inherently wrong with child pornography, or is it because allowing child pornography to go undeterred or without any fetters would encourage people to engage in or distribute child pornography? So it's really that aspect that can accrue to children. That the harm that can be caused to children that forces states to regulate child pornography. If you think about pornography in general, if child pornography is bad in general, so should child pornography. There is the only difference is that the other one causes harm for children, while the other category is not so.
Thanks, Mohammed. Is there anyone else who wants to add to this discussion?
Yeah, and one more thing. So with regard to child pornography, it's not just about recording, say, an activity. Even if, say, a book was published which had content which was referring to sexual acts with a child, even that would be banned, because I think the definition, if I remember correctly, it includes literary works as such. So even such kind of books can be banned. So this is just to like refute the fundamental argument that okay, all child pornography is banned, but all obscene books are allowed to give the choice to the individuals. Even books which contain these kind of activities and descriptions would be banned because of the larger social implications on the right to self-determination of the child, as I had previously raised.
I think that they dealt with this in Ashcroft. So they basically said, if somebody looks like a minor, it cannot be called child pornography. So it really depends whether it involves the fact that it involves a child should be material in determining whether it's child pornography. The mere fact that it mentions a child having sexual intercourse or teenage sex does not really amount to child pornography, because literature is awash with such instances, and you would have to ban every book saying it's child pornography. So you really have to look at the parties involved and whether it causes harm, because I think harm is a very important factor in prohibiting child pornography.
I personally feel that the US example of free speech should not be used as an example, because they are way too liberal, which, like, I think instances like these, it's very clear that they can be used to cause a much more larger harm to society, rather than just those people just yelling that I have free speech to say everything that I want to, irrespective of the consequences. I think from a constitutional perspective, that's where we have reasonable restrictions within India, but it is much more liberalized in US. It may be beneficial in certain aspects, but I strongly feel that it is not beneficial in aspects like these.
Is there anyone else who would like to add something? Okay, maybe then I can conclude this activity. And when we did the activity ourselves, we did also come to similar conclusions. We did look at, of course, like you all mentioned, the community standard test, the Miller test, and to sort of see the social importance of pieces like Lihaf. And yeah, at the end of the day, I feel like the time, the community, the standards will all change, and the courts would take a decision as per the current standards that are followed. And when we talk about something like the court saying, oh, if there is certain content in a book, you shouldn't read it, I feel like it's also necessary to read it in context of the rest of the judgment as well, because it's not merely that, oh, people who are offended by it shouldn't read it. It's also that the society at large is not generally offended by such writings or pieces. It's that it's in fact a publication that has been awarded, that has been heavily appreciated, and so maybe it isn't an obscene piece, but if there are people who then find it obscene, they could choose not to read it. And again, the reason we designed an activity like this is to sort of apply the provisions from US and India to different contexts, to sort of see whether they differ or if they are similar. And in this particular case, we can see how maybe they look at obscenity in a similar light. And with that, I would like to move on to our next session, if that's okay with Dr. Sitaraman Kakarela. If not, we could take another 8-minute break. Professor, if he's on, then we can. Okay.
Yeah, I'm
okay. Great.
Right. I think
okay.
we can conclude 8 minutes before, so there is no problem.
No, okay, great. So I will quickly introduce you and then give you the mic.
Sure.
Professor is the director of the School of Policy and Governance of Azim Premji University. So he did his master's in political philosophy, LLM in human rights, and his PhD in political science from the Center for Social Studies, South Gujarat University. He was the vice chancellor of Gokul University, Uttar Pradesh. And prior to that, he was a professor at the Center for Culture and Society and the National Law School of India, Bangalore. His areas of research are social, legal, and political theory, law and culture, human rights, comparative law, and comparative constitutionalism. Professor, you can now take the floor.
Yeah, thank you. I'm quite heavy, professor attribution. So you can just call me Ram. Thank you. Friends, I have been following. I'm sorry I joined a little late. But I think probably I substantially followed the conversation that happened. I'm very glad that all of you are interested in speech and also many specific areas of concern that you reflected on. I think what I'm more inclined is not really doing a comment on what you said. Maybe there will be an implied thing. Not getting into the nitty-gritties because I think you spent enough time and I don't want to bore you with that further. But I want to ask few basic questions on comparative approach to law, but also freedom of expression, and say that maybe, you know, there's something that unless we address some of those concerns, the conversations of the comparative kind, purely rooted in what I would call a functionalist approach, would be of some use, but I'm saying I'm somewhat unhappy with remaining there. That's the reason why I thought I should raise that broad question, and maybe we can even look at the way the free speech question, you know, evolved in both the jurisdictions and so on. So I'll take probably about 10 to 12 minutes to state what I have in my mind, and then maybe we probably can spend about same amount of time in reflecting on what I'm raising or trying to suggest for discussion. So I think, you know, there are various ways in which one could understand why comparative method is helpful. I mean, I think in law schools, it is taken for granted as, you know, as though it's a kind of a natural way of borrowing ideas, etc. You know, we know very well the comparative method exists beyond law as well. There's comparative sociology, there is comparative politics, and so on and so forth. So comparative method, what kind of role and function can and should it play, I think is a question that I would be very much interested in. So I personally feel, for instance, a comparative method is very critically important in understanding the global history of law, right? So for instance, you know, when we study jurisprudence in the law school, we study as if, you know, analytical positivism is a kind of a universalism that needs to be taken for granted. Quite like functionalism, which tries to look at what judges said in America and what judges said in India or somewhere else, and then try and, you know, do a comparison of where there seemed to be higher similarity, where there seemed to be some disagreement or difference. Is that because, as for instance, I think Naveen or someone was saying, as because, you know, America is too liberal a society and therefore there are certain kinds of judgments, and India probably can't afford to be that liberal and therefore some other kind of judgments. I'm saying that, to me, you know, it's kind of a lawyerly reasoning by which one is skipping something more profound to understand, is what my submission is. So therefore, I would say comparative law is something very critical resource to understand global history of modern law. And when I'm saying modern law, you know, for us, modern law is 150 years old. Frankly, it came through the colonial, and we can't ignore that kind of context, etc. The modern law, as we inherited in our common law framework in India, for instance, is not something that's simply transplanted. And if, for instance, you look at Professor Bakshi's sociology of law in India, you would recognize that as the modern law is taking root, it is also transforming along with existing forms of interpretation, existing forms of legal concepts, and so on and so forth, right? So in other words, the law that we understand in India as modern law is not only a common law that came in, but got hybridized and then acquired, you know, a particular way of interpreting and generating meaning to legal concepts in the Indian court system. So I think that's kind of a thing that we need to really look at. The second, I suppose, is a point that I borrow from an important comparative law scholar in recent times, Pierre Legrand, is a Canadian scholar who basically argued that, comparative law in functionalist frame is generally done in order to understand similarities, right? You're trying to explore freedom of expression, right? So how much the Indian sort of understanding or the doctrinal framework is very much similar to US, or where does it differ? If it differs, is it because of the nature of society or something else, etc., right? So that's the point. But Legrand's point is that the very purpose of comparative law is to understand difference. In other words, instead of focusing on similarity, Legrand argued that by focusing on identifying difference, and just not identifying difference, then you need to explain why the difference, right? So that's the other part that we need to do. Then we will be able to do, we will be able to benefit from comparative law enterprise more fruitfully. I mean, I think that's a claim, obviously one has to really see. In other words, the purpose of comparison is not so much to look at a bonhomie similarities, but rather trying to understand, despite being modern law systems, despite being in the same family of legal systems, why is it that certain kinds of thresholds are very different, the meanings are different, the jurisprudential construction of a remedy is different, and so on and so forth, right? So in other words, the purpose of comparative law, therefore, is upside down, trying to look at more difference and explain why the difference is. And I take a second point from there to say that if we at least prima facie take this point as a useful thing to engage with in doing comparative law engagement, then we must actually go beyond functionalism. So I would say dominant methodology in comparative law today is functionalism, but we should try and go towards law in context approach. Some of you, when you were reflecting, for instance, with case law here in the Indian context, or some historical cases, I think you were speculating certainly a law in context sort of gesture as opposed to functionalist mode. I'm not sure whether you were self-conscious or not, but I'm certainly saying there's something to go. And I will say very quickly a few things as necessary for doing this comparative framework in law and context kind of thing. So one, of course, we certainly need to go beyond the letter of the law. So in other words, yeah, there is a statute here, there is a constitution here, and we are trying to look at the provisions. I think that's the textual analysis, which we must do. That's the bare minimum, but we should go beyond. And one of them certainly is, I think, looking at constitutional histories. I mean, that I suppose goes without saying, from the purpose Constitution served in the making of the nation to the specific ways in which the Constitution articulated the rights and the restrictions on those rights, right? So that both, I think, becomes important. I'll quickly come back on that in a moment, but let me just say a couple of other things that I feel we need to look at. So we also need to look at interpretive legal traditions. In other words, it is not that the interpretation is a rational and therefore universal exercise. It is in some sense, but there is also a variety of other considerations, the social and political context coming in the making of those interpretations. And unless we make those connections, the rational interpretation alone would not help us understand why a particular case was decided in a particular social context in that sense. The third, I would certainly say, looking at the way we should understand the belief and strength in the institutions, right? So what you would call in the constitutional or conventional sense, separation of powers or rule of law or those kinds of things, right? That's, I suppose, is something that I feel is very much. You mean to say that every interpretation has to take this, but I'm saying not that for everything you have to look at it, but for instance, in order to understand how certain interpretations come in a particular point of time, one way of looking at perhaps is the belief and strength in the institution's question. Okay, so that's, I suppose, I would say some pointers, not like exhaustive list, but I think some of the key pointers in law and context question, if you were to take on board for doing the comparative work. Let's quickly take, and I'm doing a very broad brush, and with that point, I will just, stop my comment. If you really look at the way, the freedom of speech question between US and India ought to be looked at. So one possible way then is to see what did the Constitution serve as the primary sort of role. So in other words, is the American Constitution's intended purpose and the Indian Constitution's intended purpose would be of somewhat comparable or similar, or is there some kind of a difference? And there I would very, somewhat loosely, quickly saying it, somewhat cryptically. So if I suppose there is some debate, we can come back to it. If you really look at the American Constitution, we know the context in which the Constitution emerged and the need for keeping the, somewhat the agglomeration of states that came together and keeping them in one sort of, national framework. And there is a lot of negotiation that happened between all these very, co-equal entities of sorts, and that we know. And in the context of India, if you really see, I think it is very well articulated, and I think there are many people who emphasized on it that besides, deciding a kind of a framework for the nation building, there is also a kind of a transformative goal that Indian Constitution very much has. As opposed to bringing stability, there is also a desire for transforming a kind of deeply unequal in the social and economic and political sense society into an egalitarian society, for instance, which is there very much. From there, I mean, that's a very broad point. But if you look at freedom of expression, you look at 19.1a and 19.2, which are very much part of the Constitution. As a result, I would certainly submit a broad point that what the courts have repeatedly tried to do is to interpret whether the restrictions imposed in whatever name and in whatever class of cases that may have come before them fall within 19.2 or not, right? So in other words, there is the whole wrestling that the Constitution already mentions certain core restrictions or clawback provisions, and whether the state action is very much in tune with the clawback provisions that the Constitution presents to us or not. Whereas if you really see the 20th century case law of the United States Supreme Court, you would clearly see, I think, initially there was this tension between absolutists who believed, well, First Amendment has no restrictions and therefore it is really something not to be constrained by anything, right? So I suppose, especially with regard to, freedom of speech and writing, right? Those are the two things. Maybe expression, we don't know, but I suppose there could be some other kind of considerations, etc. But from there to the kind of early 20th century case law till about, I suppose I would say Texas versus Johnson, what you constantly see is the court refining, repositioning its views on what is the nature of restriction the state can legitimately bring to the First Amendment guarantees, right? So in other words, it's every time, it is almost like a near absolute position, but the footnote must be very clear, must be very, very, very sharp, and so on and so forth. So that wherever there is vagueness, wherever there is ambiguity, wherever there is some kind of an overreach, immediately the courts went in favor of the First Amendment. I'm saying if you just take this very broad kind of a brush point from my side, that there is a difference in the context in which the constitutional provisions emerged. There is a difference in which the discourse on what constitutes speech and what are its nature and scope. And therefore, the judicial interpretations can't be very independent of that, right? So you were talking about obscenity cases. I'll give one anecdote and just leave it there. And that is, you take 1920s Ulysses case, for instance, or the case of Well of Loneliness, which is the first lesbian novel in the UK. Both authors are from UK. And the UK courts, right? 1920s one case, 1930s another case. Both books were banned. And I suppose you need to interpret why a quote unquote very liberal society like UK had to ban. And when the publishers, of course, took the same matter to the courts in US, I suppose they were permitted to publish, right? So you can see, even within this Western liberalism, there are differences in looking at obscenity question or expression question and constraints that can be imposed meaningfully and so on. So I'm therefore urging all of us to really see comparative project as something more than looking at formal logic. And there is need for understanding law in context approach to, expression or any other questions that we want to understand. I think expression is an excellent area for a comparison between US and India. And I would certainly submit, the more we look at the law in context, the more we see the reason as to why we are thinking differently. Is that liberalism? I think that is also a broad point. I mean, just because Naveen raised, I'm talking about it. Is that all about a liberal thing? I don't really know, right? So in other words, I would say, well, I'm not sure whether India is less liberal or whether we should view us only from that vantage point. What really is the reason why our politicians are very touchy and anything that comes as a reflection on them would become a point of constraint or restraining in this country? And, well, why is it not in the other jurisdiction, for instance? Is it just because of First Amendment, or is it because of a wider social ethos with regard to what could be said and what could not be said? So I'm also impliedly suggesting the law is not independent of the larger discursive ethos that a society entertains. And I think that probably is something that we should keep in mind. Thank you for this opportunity. I thank CLPR and colleagues for anchoring this. But I don't have much points, right? I just said my point as you were saying about your points. Thank you.
Thank you. Thank you, Professor Ram. I will now ask the students to ask Professor Ram if they have any questions. Maybe give them a minute or two to.
Yeah, absolutely. So it's all right. Even if they don't have anything, I'm quite okay.
May I ask a question?
Yes, of course.
Yes, please.
Firstly, thank you, sir, for that talk. So, sir, you mentioned that we have to look at whatever constitutional provisions that were implemented in the context of what was initially thought, or what the makers initially thought, or the history behind it. But couldn't that at times backfire? Because, for example, if we look at when Jefferson wrote that all men are created equal, he didn't essentially have people of color in his mind. So, and that was the context in which he wrote it. So if we interpret it in that context, wouldn't we still be living in a regressive society?
Okay, I'll give a counter example. The reason is this, that there was a Sedition Act in the United States in late 1790s. And many of Jefferson followers were actually, incarcerated because of their protest on some count, and that was seen as seditious protest, and then they were, arrested. Of course, soon after that, Jefferson became president, and then all of them were pardoned by him, and the act became, redundant, I think by about 1801 or something. So the reason why I'm saying is it's true that there are so many limitations that we will find in the so-called constitutional designers or constitutional masters of in any national context. Would we, I mean, therefore, I would say the point there, what you are trying to suggest is, should we take, when I'm saying historical context, my reason why I'm saying is to understand the context in which a particular debate is taking place and why a particular group or, a particular institution like the court is taking the view that it has taken, right? So that's, I suppose, is to understand and interpret that. If, for instance, beliefs in slavery are very much part of certain kind of criminal law jurisprudence in the United States 19th century context, so be it. And I think we need to understand. So therefore, just because the Constitution said all people are equal, in the US for over 100 years, we know post that Constitution, there was slavery. And we have a series of, declarations, if I want to bring in, there is actually a volume subsequently published by Afro-American people called We the Other People. That's counter to We the People, which is the defining part of the American Constitution. Right? So I'm saying, so there is no reason why we shouldn't talk. I mean, in a very similar way, I don't know whether you came across this piece of Bakshi, Constitutionalism as a site of state formative practices. What is the reason why he did that piece? He is reflecting on two important constitutional law scholars of our time. One is Kenneth Cast, who teaches in the US. The other one is Yash Ghai, who is a Kenyan, but did an exceptional work of constitutional, designs and constitutional drafting in many common law countries. So Yash Ghai is a very prominent figure in that sense. So Bakshi's one part of reflection is, how would you write American constitutional history? Would you see it as a great document of freedom, liberation, ABCD? Or would you also need to account for what happened to Afro-Americans, what happened to Native Americans? And really, the constitutional history of America must account for, lack of freedom for certain groups. I mean, so in other words, extending the point that you are saying, so if Thomas Jefferson is a racist, which he was, and held slaves, which he did, we should say it. But at the same time, if he has certain kind of conceptual contribution in imagining a constitutional order, and then thinking about questions of freedom, for instance, far more radically than many of his contemporaries, we should probably acknowledge the same as well, right? So there is no reason why we should reify and think Thomas Jefferson as a great Democrat of an exceptional order. He is a human being. He has certain democratic tendencies. And because of the historical time in which he also was susceptible to certain kind of prejudices, certain kind of beliefs, which were certainly not democratic by any measure. I would further extend the point to say, please read Mahatma Gandhi's first 12, 13 volumes and try and see what kind of views did he sustain on the Black Africans, because see, he lived in South Africa for a reasonable period of time. You must try and read firsthand, right? So if, for instance, people in Uganda or in some other places in Africa or even in South Africa, for instance, have objections to his statue being there in some sense because he held racial beliefs, I think that's the kind of a dimension we can't ignore. There is no reason why we should imagine the Mahatma means a clean and pure soul from beginning till the end type. No, everyone evolves. And I think that's the point that I would submit. And just because Mahatma Gandhi was susceptible to racial prejudices in his early days of career in South Africa doesn't mean that the contributions of Gandhi would go away, right? That's the point I'm actually submitting to your consideration.
Yes, sir. Thank you, sir. That was very insightful. Thank you.
Sir, I have a question. Sir,
Yes.
so basically, when the American Constitution was drafted and later on when the First Amendment was brought in with regard to right to free speech, I think a lot of the population which it intended to govern was the white population. And they wanted that right to say whatever they want without restrictions. So, like recently, we are seeing that concept of right to offend also being a part of right to free speech. So I think when we say that the US free speech laws are overly liberal, I think it is that kind of lack of restrictions which we are referring to. And when such laws and those amendments have been passed by such slave owners and white supremacists of that time, is it really beneficial for us to look up to that constitution which was drafted by such slave owners and white supremacists and try to take away options from there? Because the entire intention of that time was completely different. So does that really suit our society? And especially given that our constitution framing was much more democratic compared to that representative of a lot of different and diverse voices within India. So is it really apt for us to look up to the US Constitution every time we need to make any changes within our Constitution? Because I personally believe that the fundamental premise on which the US Constitution has been drafted is very definitely not something we need to look up to. So, what are your thoughts on this?
So I'm, Naveen, slightly disputing your basic assumption that the purpose of comparison between a constitution like US and our own is to learn and incorporate from them into ours. I think that I'm disputing fundamentally. I think that's not the purpose of a comparative project. There may be certain kind of what one comparative scholar said. There may be certain kind of dialogical borrowing, etc., may be there between the institutions that are vested with the authority of interpretation, like the courts, right? So it is quite possible that the courts might draw something and interpret it into the contemporary context of that nation and see whether it is useful or not, right? That's, I suppose, is the way one can and probably should look at the judicial borrowings or dialogical borrowings in whatever way. And beyond that, I would say the purpose of looking at other constitution is not so much to emulate, copy, which I suppose I agree with you to the extent that there is a dominant trend in all the national law universities in India, especially those who do PhD. They pick up a theme. I'm sorry for being very nasty to that group. They pick up largely, I think there is a number of dozens of PhD themes I looked at. They pick up a theme and they look at, oh, India doesn't have a law or the law is inadequate. So therefore, what we need to do is to borrow from UK, US, Germany, etc. Right? That kind of a project is a hugely problematic project because it's not helpful to us in any way except giving PhD to the person. I mean, one may be able to do a dissertation on it, but that's really not helpful. Therefore, my submission is we are doing a comparative exercise to understand how a constitution is functioning in a particular socio-cultural context. That insight we must get. In other words, if we are looking at why clear and present danger test, what is the context in which such a test has come, rather than saying, can we apply clear and present danger in our context? That's the point I'm saying. Unless we have clarity as to when and in what context clear and present danger was formulated, what is its life cycle? Was there a conflict within the Supreme Court and whether there is a back and forth that really happened, as it did in the case of 1920s and 30s? And whether such a standard is sustainable in any other society than those kinds of contexts. So that's the point I would submit, rather than I agree with your implied point. Should we emulate? No. But should we try and, in other words, what is culture? Culture is a reciprocal understanding. What, in other words, I would put this metaphor, right? So for instance, if I begin to say what is right to, a young 17-year, 18-year-old law student, and think nothing else, take my word, this is what right perspective is, then I'm doing a sort of a damage which is quite significant, right? So in other words, even if the student has some kind of a feeling, oh, I'm a good teacher, and so therefore whatever the teacher says is good and I must take it intact, is the same kind of a problem, metaphorically speaking, right? So in other words, knowledge is something that is reciprocal, not given or received. So we need to really make these interaction of comparative sort of knowledge question as reflexive and therefore as reciprocal as possible. If the institutions are not reciprocal, we know very well American Supreme Court doesn't refer to any other Supreme Court. So therefore, there is no reason why our judges must refer to them. That's not the point I'm saying. But if there is a interesting concept, and if that concept makes sense to really have some reflection possible in the Indian social context, I think that's quite fine to really do. Whereas modern formalism practice is simply borrow the concept and somehow put it into the text, and therefore we see, oh, we have put Hicklin test, oh, we have put clear and present danger, or marketplace of ideas has come to us, and so on, which is not true, frankly. The moment actually you see the concept is embedded in the judgment, the meaning that that particular concept is generating is very different, or likely to be different. That's my claim. Can be proven wrong. I would be very happy to. As compared to the way, the concept gets embedded in the judicial reasoning in the United States. That's the kind of point I'm submitting. So in other words, I'm not disputing with what you're saying in the substance, which is, should we borrow? The argument is no. But at the same time, my further question is, we are not doing comparative law only to, emulate. We are doing comparative law to widen our understanding of how modern law functions. What are the contexts in which modern law acquires its meaning, right? That's the kind of question comparative law should ask, as opposed to, hegemony of American Constitution coming to descend on us.
Thank you, sir.
Thanks.
I think maybe we can wrap up over here. And if any other students have questions, please feel free to send them to us, and we can see if Professor Ram could maybe later answer them. Thank you, Professor, for taking us through this, through the role of comparative method, and understanding the history of law. I think this is one of the main reasons why we actually conducted the workshop itself. And it is in fact important to move from a functionalist approach to see how, to see law in context of the time. Thank you, Professor, for joining us. And I also wanted to mention that Professor is actually a trustee of CLPR and works closely with us. So thank you for being a part of this session. Thank you to all the students. Thank you, Usha. Thank you to the faculty of NUALS. And with this, I think we come to a close of session 2 of our workshops. We will have session 3 today evening. So Professor, if you're available, please feel free to join us for that session as well. And that's when we will have the interaction with the US students. So hoping to see everybody at 9 p.m. tonight. Thank you. Thank you all. Thank you for joining.
Thank you.
Thank you.
Thank you.